It is not available, Lordship.
Are you on interim?
Yes, Lord. Interim may continue.
Yes.
17th of
17th.
Much obliged, Lord.
May I please watch paper lots pardon my lord. I think 25 minutes. Can you come after a week?
25.
25.
What is the position of 25? Not received.
Yes.
Are you on interim?
No one.
Not. After a week, you want?
Any date, my lord? September. First week of September.
At the request made by candidate counsel for the petitioner. That raise that to CD. Not received. Please check. Yes. Fifth. Can it be? Okay. 5th of September.
Obliged.
May I plead, Your Lordship? I beg to mention item 19 of today's list. CD is not there, Your Lordship.
Item 19.
19, Your Lordship.
Are you on interim?
Yes, Your Lordship.
Divine. CD not received. Issue. Yes, 79 and
17.
so Bishopura Puja don't give much.
Oh, yes. 11th of
Oblige, Your Lordship.
May please, Lordship. First, I have to mention for listing in anticipated bail application tomorrow, Lordship.
No. Tomorrow list is already covered. We are full.
And Monday, Lordship.
Monday is a holiday. Maybe by Tuesday or
Tuesday.
Wednesday.
Tuesday. Obliged, Lordship. May please, Lordship. Lordship, I beg to mention item number 24, my lord.
24.
My lord, kindly 27, my lord. My lord,
Huh?
27, my lord. 27 September.
27.
September.
You want an adjournment today?
Adjournment.
Not 27. We have fixed exam.
24. My lord. Next date fixed.
This group we said. 27. There are some items in fact there.
My lord.
It may not reach also.
22nd September fixed date, my lord, quote below, my lord. Next date fixed.
22nd September.
September.
Okay, we'll give you a prior to that date only. It's a AB, na?
AB, my lord.
Okay.
20, my lord, 28, 29. 20.
15th of September. As it is a AB only, we are listing it. It's a charge sheeted case.
Yes, my lord.
Your matter is fixed on
2nd September.
2nd of September. 2nd of September, na?
28, 29.
No chance. 30, 31 is a holiday. 30 is a holiday. 29. Okay then.
I love you.
At the request for you.
May it please the Lordship. Lordship, may I pray for listing of a bail application on Tuesday? I beg to mention item 17. CD, item 17. CD is also not available. We are on interim, Lordship.
How many petitions are there?
2, Lordship.
2. They are interim?
Yes,
Both
Lordship.
of them. They did not receive treatment to be extended. Yes, both of them. 11th of September.
Obliged, Lordship.
May I please, Lordship? One of the petitioners arrested on 26 July, when it was 27 days. Allegation that, my lord, the present petitioner came from Mizoram to purchase fake currency from the co-accused, and he was carrying 11 lakh genuine notes. And when the co-accused showed the fake currency, he found it is poor quality, and he denied to take that money. And
I is allowed by they came here for my purchasing paper and
yes,
Purchasing paper.
but he is saying the story different.
Acha.
Case diary will
He
remain.
refused to take those currency.
He is saying that, no, I have not come to take purchase fake currency. As a
So why,
businessman,
what currency he wants to purchase?
a genuine currency he was
So
carrying,
he,
that money was snatched away by the co-accused. That means allegation that the present petitioner came from Mizoram and contact the co-accused
for purchasing those fake.
purchasing the fake currency, and he's carrying 11 lakh genuine currency. He will take more. In the meantime, they when sit down in a place and found the fake currency is poor quality, then he denied, I will not take this.
As per FIR.
As per FIR, then they had what happened? They snatched away that 11 lakhs from him, the genuine note, and assault him. And then he went to the police station. Then police, after getting the information from
Oh,
him.
that means
and-
informant came here to purchase fake currency.
Yes, yes, that is the case. But he is saying, no, I have come to purchase the grocery item. I have the wholesale. And they have falsely saying that I have wholesale grocery item, I will give you. Accordingly, taken in a house and money snatched away. But my intention was not to purchase any fake currency. That is the case. Now he is the victim, as well as per informant, the police is the informant here. As per police, he is the accused here. But as per his statement, he is the victim. But nothing was recovered from his possession, that fake currency or any related fake currency. So the case diary may be called for.
Yes, what?
On 10th of September.
10th of September.
I am obliged to.
And
May I please, Lordship? It is 483 bail application granting bail to the accused persons petitioners, namely say number 1 Saidul Islam, number 2 Tal Islam Sheikh, number 3 Muhammad Mansur Ali, who have been arrested by the Sonapur police in connection with Sonapur PS case number 121/25 under section 303 subsection 2, 329 subsection 4, 317 subsection 2, 3 subsection 5. We are behind the bar since 3rd August, 25 days. 90 days we are behind the bar. Have a look at the page 15,
Third,
the English translated
since
type
when
copy
you
of
were in
FIR.
custody? Since when you were in custody?
Lordship,
You got arrested on which day?
on 3rd August 2020.
3rd of August.
Yes.
Then how 90 days?
19.
Oh, 19 days.
19.
Okay. See, as per the FIR, I think
Page 20 is the grounds of arrest, please.
page
20. 20. Ground number 3.
got red-handed.
Getting
He was swing machine and he was loading in a
Subsequently,
Tom Rich.
Lordship.
Now see, what red-handed matters, and have you annexed any seizure list here?
Yes.
How many swing machine has already been seized?
Swing machine 14 numbers.
14 has already been seized.
Yes. Abandoned machine, Lordship.
See whether it is an abandoned machine, because all the machines, how this, it's a good quantity of number, I mean, good numbers of the machines. So let us is diary be fixed. Yes. But 10 of that also.
Short date, kindly, Lordship.
Short date as such, we don't have. It will be on 10th of September itself, Steve. 10th of September.
Obliged, much obliged.
Please, Lordship. And the matter will be taken some of the time, after some time. Deep here.
Yes.
Report was supposed to come from.
Oh, it's a
whether there is any case on.
Report we have received. Till now, we don't, no case has been, registered in Olivet police station against. In the event if some case is registration is there, then definitely you can come with it. At this stage, we are disposing of it. Mr. ended chocolate, so Mr. P. bought. Master bought report submitted receipt of all women police station. Where it is reported that till date there is no case been registered against the patient. In view of this, we gave representative. It's on representative. So, the petition is given the appropriate forum if in the event of registering any case.
Of the lordship. I might not claim accused, but here in this case, report from Hatinao police station not written. Accused
For same accused. Why two cases? I mean, one is for Oloman police station, another one
because
Hatigaon.
as per our knowledge, petitioners informed us that in two police stations, similar kind of complaint may have been raised. So we have filed two ABs for two different police stations. So if lordship,
So from Hatigaon, have you received any information?
then lordship date may fix, let that report also come lordship from Hatigao.
So you have the apprehension that in these
Maybe
two police
lordship,
stations.
maybe lordship.
Okay, then report not received. Issue reminder. And in the meantime, the learned editor give you necessary instructions. As to whether the case has been registered against the present in the council station.
Of the
Please
lordship.
record it on 5th of September. 5th.
Of the regulation.
May I please, Lordship, this is an application under section 482 PSMS. FIR is page number 11, my lord. May I read? সন্মানপূর্বক বিনীত নিবেদন এই যে যোৱা ইংৰাজী ছেপ্টেম্বৰ 2021 ওপৰত উল্লেখ কৰা পদক্ষেপে মোৰ ঘৰত আহি চৰকাৰী আঁচনিৰ টকা বেংক একাউণ্টত সোমাই দিম বুলি মোৰ পৰা আধাৰ কাৰ্ড আৰু পান কাৰ্ড লৈ যায়। পদক্ষেপে প্ৰবঞ্চনাৰ বিভিন্ন প্ৰলোভনেৰে প্ৰলোভিত কৰি বিশ্বাসঘাতকতাৰে উক্ত নথিসমূহ লৈ গৈ অনলাইন মাধ্যম যোগে মোৰ নামত ঋণ লয় আৰু মোবাইলৰ OTP সংগ্ৰহ কৰে। মোৰ নামত প্ৰায় 4,000 টকা লোন লৈ যদিও বৰ্তমান পৰিশোধ কৰিবলগীয়া টকা প্ৰায় 9,000। মোৰ অজ্ঞাতে পদক্ষেপে প্ৰবঞ্চনাৰে উক্ত ঋণ কাৰ্য সংগঠিত কৰে। উক্ত কথা মই যোৱা কেইদিনমান আগত অৱগত হওঁ। পদক্ষেপে আমাৰ গাঁৱৰ প্ৰায় 20 জনৰ অধিক নিৰক্ষৰ লোকৰ আধাৰ কাৰ্ড আৰু পান কাৰ্ড সংগ্ৰহ কৰি প্ৰায় 2.5 লাখ মান টকা ঋণ লৈ নিজাববীয়াকৈ আত্মসাৎ কৰে। This is the allegation, my lord. Actually, petitioner is not involved in this case, my lord. My lord, the petitioner, two petitioners are there, Babul Ali and Mustafizul. I am for Mustafizul Haq, and Mustafizul Haq alias Mustafizul Rahman. Mustafizul Haq did not go to the employment house, your honor, my lord, and he is not collected the PAN card or Aadhaar card or ATP, my lord. My lord, this incident was took place on 2021, and allegation brought against them 2025, my lord. But this is false allegation, my lord. He neither go to the
informant house to collect the PAN card and Aadhaar card and OTP, my lord. So, my lord, CD is available in my lord, code number 21 and item number 21. Yeah. Babul, for the Babul Hussain. He's arrested and CD was called for him and CD is available in code number 24. Yeah. Item number 21.
We cannot.
24,
the-
code number 24, item number 21.
No, whatever, we cannot interfere the proceeding of the other court.
Kindly fix it on
But till then, CD may not be available. He want to submit that the CD is available.
Yes, sir. Yes, my lord.
We'll take care of it. Then he is suggesting, Mr. Burba is suggesting that we can pass an order because he is submitting the item number so and so cases record is there in the code number 24. So we make a order accordingly, please before this, then it will be immediately. it will be
This is his submission that may be recorded.
So obviously, his submission.
I am not aware of whether it is received or not.
You are aware of. The CD is available.
CD is available. I already connect there. I go there.
You also
I
agree in that
inform
case
from,
also.
I inform from PP, my lord.
So you have the information. Okay, your good name S.A. Ahmed.
A.S. Ahmed.
Part Mr. A.S. Ahmed, Learned Contact for the Petition House. Part Mr. E. Watergood, the Learned Additional PPF. State response. While at the time of deliberation, it is submitted by Mr. Ahmed that CD of the present case is available in the court number 24.
Yes.
In the court number 24, which was called for in connection with the item number 21.
21.
Item 21. Can you tell the item number? I mean case number.
Case number
Item number
2578.
Huh?
BA 2578 oblique
BA
25.
2578.
2578.
2578.
Yes, my lord.
Item number 21, that is BA 2578 total. In view of this, let the present case be listed before the coordinate natural school and the registry will do the okay. We're sending details.
Malaj, I'm so sorry to mention a matter out of turn, Malaj.
Huh?
Item number, I'm so sorry to mention a matter. Item number 32, an additional affidavit was filed yesterday. That may be called for, Malaj.
Item number 32.
32. People Kumar Post, Malaj. Criminal Division.
32, na?
32.
32.
I'm so obliged, Malaj.
May I please, Your Lordship? The allegation is very serious one, Lordship, but in spite of that, Lordship, two ladies are there, Lordship. Lordship will kindly turn to page 8 is the FIR, Lordship.
Yes. Yes.
Lordship. Most respectfully, it is submitted that about 1 year back, my daughter was married to below name, below mentioned accused number 1. Since last 6 months, the below name, below noted accused person have been torturing my daughter mentally and physically. On 2/8/2025 in the morning, my daughter Arifa Khatun committed suicide by hanging. When the said information was given to me by my family members, I came to the place of occurrence in the evening. From the neighbors, I came to know that the accused person fled away from the house when they heard about the committing suicide by my daughter. I suspect that the accused person killed my daughter and hanged her and fled from the house. Therefore, this is a request to investigate the matter and take all the family members has been named in the FIR, Lordship. Here one Lordship mother and the grandmother is also named in the FIR, Lordship. That is why, Lordship, praying for the 3% that they are in the petition, Lordship. I am praying for the mother and the grandmother, Lordship. And the rest are arrested, Lordship. One person is arrested. Father is arrested, Lordship. The husband is still left for me.
You must use what they call closed area. CTP call. Fifth of September will be fifth of. Fifth.
Lordship. Much obliged, your Lordship. Much obliged.
What is the position? What have
Marital was that identity of the accused.
Yes, I have received the report, my lord.
report?
Separate.
So you are for the Asadul Stano.
Son of Saeed Ali.
So report is very clear.
Yeah.
Two Asaduls are in.
Two
One-
Asadul.
Yes,
Involved.
one is of this Asadul.
But your Lordship,
Son of-
kindly see all this, my Lord, they just, my Lord, date of occurrence is, my Lord, actually 2/3 FIR is filed. Just 2/3/25
FIR.
FIR, my Lord. And your Lordship, those FIR named accused persons were arrested, my Lord, on your Lordship's order is there, my Lord, your Lordship is at page 26, my Lord. So as for 2/3/25. FIR accused arrested on 2/3/25. And they are released by your Lordship's order dated 3/4/25. Thereafter, after about 3 months, when Panchayat election was over, my lord, this person was involved, we have stated on oath, my lord. He was involved in a Panchayat election, my lord, campaign in favor of some other candidates, my lord. And because of that, after 3 months, my lord, he was taken to custody, my lord. No whisper in any other, my lord, in the forwarding report of those 3 persons, my lord. Nothing is there, my lord. And his house was also searched, nothing was obtained also, my lord. And paragraph 6, just have a look at paragraph 6 of my petition, my lord.
Regarding that identity report I have received, when the bills I have also received the case. I need some time because interview. Not some time.
Time.
Regarding
Let him
Your
go.
petition is in custody since when?
Well, no?
This petition is in custody since when?
He was a 7/2, my lord.
7.
2 days, 50 days, man. There were 50 days also, my lord.
After some time.
My lord, I have another item, maybe along with that, my lord, after some time, my lord. Item 13, my lord. I'm just going to another court, my lord. Just your lord.
Item 13.
13, my lord. Just, my lord, for the time. Along with that matter, your lordship.
Oh.
Obliged to.
May I please, your lordship. Lordship, on last occasion, case diary was received, though it was without FSL report.
Yes, my lord, I contacted, I owe my lord. He intimated me with the said FSL report not yet received. And regarding the materials, my lord, against the accused person, there is no direct, you look earlier also, you look, can you prove the
FIR lordship will find a vernacular page 14 lord. And the translated copy lordship will find at page 11. 38 days, my lord, as on date. Behind up.
Now you are appealing for these two petitions.
The present
I am for the Dilnur. Dilnur Ali, my lord.
present petitioner is one of the owner of a garage, my lord. And victim, my lord, he earlier worked in the garage of the present petitioner, my lord. There is regarding some caretaking is the basis of the on that the my lord, say of the incident.
Yes, he
She-
committed, yes.
And other witnesses also stated that they, my lord, show the accused person regarding chasing only that part, my lord, there. To that aspect, my lord, the statement of the
But this petitioner was the garage owner.
garage owner.
Garage owner, my lord.
But it is very surprising and how it can happen in broad daylight. I'm still not convinced. In a broad daylight, a person,
Yes,
how,
but yes,
how he can commit?
how he can come.
Ah,
Lordship, the so far the
because you see that they have also visualized
Muqaddamar-
vision.
Yes,
If you
Muqaddamar-
see a 12, 13 years boy was running and some of the persons were chasing up him
investigation.
by a motorcycle or motorbike. And then how he will reach this place, will take the rope, then hang himself. Quite
Team involvement is there, but regarding that aspect, my lord, investigation is.
very poor investigation. in that case.
Lordship, one thing is
মুকদ্দমাৰ
that
গুচৰীয়া আৰু হাতীক সোধপোছস্থলত মুকদ্দমাৰ গুচৰীয়া আৰু হাতীক সোধপোছস্থলত গুচৰীয়াৰ পুত্ৰ ইৰফান আলী পটকীয়া মহম্মদ হিলনুৰ আলী the present গেৰেজৰ সন্মুখত পাই পাম্প মেচিন চুৰি কৰা অজুহাতত ধৰ বুলি গেৰেজৰ সন্মুখৰ পৰা ডিম্পৰ গাঁৱৰ ৰাস্তাত আৰু ডিম্পৰ পথাৰত আন পদকীয়া ইউচুফ আলী, মিন্টুল আলী আৰু মইনুল আলী সহ দলবদ্ধভাৱে খেদি ফুৰা আৰু ইৰফান আলীয়ে ভয়ত পলাই ৰেল লাইনৰ ফালে পলাই যোৱা সাক্ষী প্ৰমাণ পোৱা যায়। তাৰ ফলত ল'ৰাটোৱে মানসিক ভাৰসাম্য হৰুৱাই ৰেল লাইনৰ ৰুমৰ এটা চিগনেল লাইট পোষ্টত ডিঙিত ৰছী লগাই ওলমি থকা পাই হস্পিটেললৈ নিয়া মৃত্যু ঘটা সাক্ষী প্ৰমাণ only to them. Yes, how by getting by all these accused persons immediately thereafter is practically not at all possible for him.
Maybe police may be managed.
Lordship, one of
The
the
circumstance, if you see the circumstance is very yes, circumstance.
Lordship, one of the co-accused, that is Yusuf Ali, has already been granted the privilege of pre-arrest bail by the Lanet Sessions Court, my lord, at Amingaon. So his statement might be there, Lordship. That might put some light to the
Yusuf.
Yusuf. He has already been granted the pre-arrest bail, Lordship. Asan Yusuf Ali. ইয়াতে আছে কিন্তু 7 দিনৰ ভিতৰত ক্লিয়াৰ হ'ব statement নেব Lordship, had it been a case of Lordship, the homicidal death, there must be some opinion in this regard, my lord, in the postmortem report. And so far, Lordship, the external injury is concerned, that is not there. No external injury has been found on the body, Lordship. So that might be a case of suicide, my lord. One thing is there, my lord, the chasing part, Lordship, and the
saying dhor, that part might be a correct one. But rest of the incident, because there was no eyewitness to that effect, Lordship. So how could they have narrated a story in the FIR that they have chased with a bike and all, if there is no eyewitness? And if there is an eyewitness, then that account might be there in the case diary, my lord. That is possible. It might be a case, my lord, he had fled away and subsequently he had committed suicide. So whether that part can be treated as a abatement to the suicide or not, my lord. Opinion, nothing. So far as that part is concerned, my lord, I have a definite instruction to that effect, lordship. Immediately he was taken to a private hospital at Baihata Sariali. There they tried to revive him by pumping in his heart, and subsequently he was taken to GMCH. So far the congestion part of the lung is concerned, that might be one of the cause. That might be in the case diary. He was taken to a private hospital at Baihata Sariali. He was still alive, but they asked the parents to admit him in the ICU. But instead of admitting him in the ICU, they have taken him to the GMCH. And subsequently, while coming to the GMCH, he breathed his last. I have definite instruction to that effect, Lord. Where he have committed suicide, my lord, that part may be isolated part in the railway track. That might be also a case.
Now it has become a more or less a trend.
Yes.
Because see, there is not a case of poisoning or it's not a
Yes,
case
yes.
of thing.
Yes.
And on the dissection, if there is a suppose it was a homicidal in nature or any mineral strangulation is there, that report they can provide easily. But in spite of giving the cause of death, in every cases it has sent to go for FS. If the case, you have to see the nature of it. If there is a case of consuming anything or then that may be one of the cause that it has to be sent for the FS. Without having any sort of that such thing, merely it has been sent for the FSL. Why? What was the reason? If it is supposed to sell on dissection itself, it will come out. What is there? Otherwise, there was a non-continuous like a sermon. It's there. With otherwise, for us as a layman, we can say that it may be a case of hanging. I mean suicide. But why in every case it has to be invariably sent to the FSL and which delayed the matter itself? Maybe some cases where yes, obviously that may be needed or required. Not in every case.
From the story also, my lord, it is quite difficult to believe that in that manner, my lord, while these accused persons immediately after stating, they also found immediately thereafter he has committed something.
I mean, that's what is.
Yusuf Ali's statement might put some light to the key incident, my lord. He was one of the co-accused.
The report.
But I, but Mr. Peter is still alive. But Mr. Peter, how it is submitted, Mr. What that which yeah, I was collected. Yeah, said it. So that will have it. Submit present education is in set up as a legit. All right to the back. The boy was you admit up to which part that he was
Lordship,
you are the being the garage owner, you admit that he's I mean the deceased had stolen your these things and all.
Lordship, that part is there.
Ah.
I do admit, Lordship. Stealing part is there. And on that particular day, so far my instruction is concerned, I saw him and I scolded him that why you have stole that article. So he ran away from that place, my lord. That part is there. I'm not denying that part, my lord.
That the fact that the accused was cautioned and questioned as to why he committed theft, and in that case, in that and on that the victim deceased was frightened and he fled away from this from the case. But thereafter the petitioner no knowledge and subsequently came to know that it's suicide by hanging himself. He was subject that it is within your petitioner is in custody since
Since my lord 15/7/2025, as on date, my lord 38 days.
7 he is in custody. It's that's I got sufficient opportunity to interrogate the accused. Accordingly, he submitted that therefore the petitioner may be released on bail and he will extend his cooperation in further investigation of this case. If it's further cooperation. So, additional PP submitted in history that that is the fact that the boy was chased by some of the accused persons, but that apart, but thereafter what had happened to the boy or how he committed suicide is not available in the case diary. And the PM report also speaks that it may be a suicide hanging. Expert considering this methods available in the case diary find that particular interrogation may not be necessary. It has to be satisfaction of which CGM?
Kamalpur police station, my lord.
Kamalpur.
Police station is Kamalpur, my lord. It is
Kamrup
Romia.
Kamrup Amingaon.
SDGM Romia.
SDGM Road. Satisfaction of SDGM. Okay.
Obliged, lord.
May I please, Your Lordship?
With the position of that.
Lordship, there are two petitioner, Lordship. Both the petitioner are behind the bar since 30/6/2025, Lordship. As on date, Lordship, 53 days behind the bar, Lordship.
How many?
53 days, Lordship. And the allegations are, Lordship, under section 126(2), 117(2), 1403, and 309, Lordship. Wrongful restraint, wrongful confinement, kidnapping, and robbery, Lordship. 4 sections are there, Lordship.
After kidnapping, robbery.
Yes, Lordship.
Where is the FIR? Ten.
Yes, Lordship. Page 14, Lordship, Bhane Koral, Lordship.
May I read, Lordship? মহোদয়, এজাহাৰকাৰী সবিনয় বিনীত সন্মানপূৰ্বক বিনীত নিবেদন এই যে মই উপৰোক্ত ঠিকনাৰ বাসিন্দা হওঁ। পেছাত মই এগৰাকী ব্যৱসায়ী। মই গুৱাহাটী মহানগৰীত ব্যৱসায় কৰোঁ। মই ট্ৰাকেৰে বিভিন্ন ঠাইলৈ মাল বস্তু পঠিয়াওঁ। যোৱা 20/6/2025 ইংৰাজী তাৰিখে সন্ধিয়া অনুমান 8 মান বজাত AS 25 CC 2765 মিনি ট্ৰাক নম্বৰৰ গাড়ীখনেৰে গুৱাহাটী বিজয়নগৰৰ পৰা 60 বস্তা শিখৰ পাণ মছলা আৰু 15 বস্তা জৰ্দা লোড কৰি বৰপেটা ৰোডলৈ পঠিয়াওঁ। তো গাড়ীখনৰ চালক আছিল ৰফিকুল ইছলাম, পিতা হৰমুজ আলী খান, গোবিন্দপুৰ মৌজা জনিয়া থানা বাগঘৰ বৰপেটা, মোবাইল নম্বৰ so উক্ত দিনা ৰাতি প্ৰায় 10 মান বজাত ড্ৰাইভাৰ ৰফিকুলে মোক ফোন যোগেৰে যোগাযোগ কৰি ৰামপুৰ পোৱা বুলি কয়। 21/6/2025 ইংৰাজী তাৰিখে ৰাতিপুৱা প্ৰায় 6 মান বজাত মোৰ পৰিচিত অন্য এখন গাড়ীৰ চালক হাফিজুৰ ৰহমানে উক্ত গাড়ীখন ডাবুলীয়া পাৰাত ৰাস্তাৰ ওচৰত দেখি মোক ফোন যোগে খবৰ দিয়ে। মই তেতিয়া চালক ৰফিকুলক ফোন কৰোঁ যদিও ফোনটো চুইচ অফ পাওঁ। মই লগে লগে মালৰ গৰাকীক ফোন কৰোঁ আৰু তেখেতে গাড়ীখন গৈ নোপোৱা বুলি জানিবলৈ দিয়ে। কিছু সময় পিছত মোৰ গাড়ী চালক ৰফিকুল ইছলামে মোৰ পৰিচিত গাড়ী এখনৰ নম্বৰ AS 01HC 3375 চালক হাফিজুৰ ৰহমানৰ মোবাইলৰ পৰা ফোন কৰি জনায় যে যোৱা ইংৰাজী 20/6/2025 তাৰিখ ৰাতি অনুমানিক 11:30 মান বজাত গুৱাহাটী বৰপেটা ৰাজ্যিক হাইৱেত নগাঁও পাৰ হোৱাৰ পিছত বৰবিলা গাঁৱত ৰফিকুলে চলাই থকা AS 25 ভেহিকুল নম্বৰৰ সন্মুখত এখন কলা ৰঙৰ গাড়ী আহি আগভেটি গাড়ীখন ৰখাই 4-5 জন মান দুৰ্বৃত্ত গাড়ীখনৰ পৰা নামি গাড়ীখনৰ চালকৰ আসনত বহি থকা চালক ৰফিকুলক জোৰ কৰি টানি আজুৰি গাড়ীৰ পৰা নমাই এখন সৰু গাড়ীত চকু আৰু হাত বান্ধি উঠাই লৈ গুচি যায় আৰু ৰাতি আনুমানিক 2 মান বজাত পাঠশালা নেশ্যনেল হাইৱেৰ ওচৰত এৰি দিয়ে। সি কোনোমতে ৰাতিটো পাঠশালা থানাত কটাই ৰাতিপুৱা গাড়ীখনৰ ওচৰ পায় আৰু দেখে যে গাড়ীখন সম্পূৰ্ণ খালী অৱস্থাত আছে। So here in this case, Lordship, nothing has been recovered from petitioner number 1, Lordship. And Lordship, as in the forwarding, Lordship, in the ground of arrest, Lordship, it is mentioned that from petitioner number 2, Lordship, page 18, Lordship. During investigation of point number B, Lordship, during investigation of vehicle, Lordship, point number A, Lordship, kindly. This is a serious grave case of robbery on the basis of the statement made by the arrested accused person, namely Razak Mullik. The involvement of Shahjahan Ali and Abdul Qayyum was apprehended. Afterward, following investigation, 15 number of grey color bag contains Sikhar Pan Masala and 3 number of white color bag contains SSI Masala was seized from the godown of Hafizur Rahmani, Lordship, son of Lalson. This is the petitioner number 2, Lordship. 15 number of grey color bag containing Sikhar Pan Masala and 3 number of white color bag containing SSI Masala was recovered, Lordship. And after that, again, Lordship, 1 number of grey color bag containing Sikhar Pan Masala was seized from the shop of Nurul Islam, son of late Hussein at Sontoli Bazar, as on late and shown by Hafizur Rahman, Lordship. These circumstances of the arrest deemed necessary, Lordship. Lordship, my humble submission, Lordship, on the date of occurrence, Lordship, on the alleged date, Lordship, the petitioner number 2, on the alleged date, Lordship, that is 26, Lordship. I have stated in, Lordship, para number 7, Lordship. It is pertinent to mention here in that on the day of occurrence, I 26, 2025, the petitioner number 2 was at Kolkata, and he has boarded from Kolkata on 21/6, and he has reached Guwahati on 22/6, Lordship. And Lordship, I had annexed the Lordship train ticket of the petitioner, as well as Lordship one purchase receipt where he purchased at their Lordship. That is, those are Lordship in train ticket, Lordship, train ticket, Lordship, page number 34 and 35, Lordship. 34 is 15 June. He, from Guwahati, he went to Lordship, Kolkata, Lordship. And page 35, Lordship, 21 June, Lordship, he boarded from New Farakka Junction to Guwahati, Lordship. And page 36, Lordship, at the bill, Lordship, he purchased it in the name of Hafizur Rahman of Azimgarh, Lordship, that is in West Bengal, Lordship. So he was not present at in the state of Assam during the occurrence, Lordship. Maybe, Lordship, it is alleged that that is recovered from the possession of the petitioner number 2, Lordship. But if it is recovered also, Lordship, then also the section of robbery will not attract, Lordship, and otherwise, Lordship, 53 days behind the bar, Lordship. And in the forwarding, Lordship, the investigating agency also not sought for, Lordship, the custodial interrogation of the present petitioner, Lordship. So my humble prayer, Lordship, for the sake of investigation, Lordship, already 53 days behind the bar, IO has got sufficient time for custodial interrogation of the petitioner's, Lordship. So any condition, Lordship, they may be allowed to go on bail, Lordship. And furthermore, Lordship, they are permanent residents of, Lordship, Kamrup Rural, Lordship. They are within the jurisdiction of this court, Lordship, of Kamrup Rural, and they will be available to cooperate with that investigation, and if charge sheeted trial also, Lordship, they may be allowed to go on bail.
My lord, this is the case that they are the one of the culprits that were involved in this incident. Yes, Shahjahan Malak is the driver of the vehicle, Malak, who drive the vehicle and followed the loading vehicle, Malak. And after that, it was loaded in his vehicle, Malak. He was the driver. It was loaded in his vehicle and taken to the another place, and it was Malak. Several Malak takes were recovered from the godown of the second number, petitioner, from the petitioner number 2. And Lordship, my lord, that Lordship may appear the statement of the one of the minor, that is will be clear from him, my lord, how they have planned for, my lord, committing dacoity, my lord. It was section 310 up to as it later on, my lord. 310 subsection 2. And another edit, my lord, 312 subsection
310 subsection 2. This is decade.
Yeah.
And
312 organism.
111
Subsection of the organism. Sufficient materials are there, my lord, and it was also yet to be recovered, my lord. 44 bags of Sikhar pan masala and 12 bags of Dorda is yet to be recovered. Whole truck they have unloaded, my
Lordship, 53 days already, Lordship,
lord.
and
Not at this stage.
Lordship, and in respect of 111 Lordship, I beg to submit that to attract 111, Lordship, a organized crime, there must be previous case which is charge sheeted, Lordship, against the petitioner, Lordship, and the trial court must have taken the cognizance against the petitioner. Then also the Lordship, organized crime.
Against some of them, my lord, several cases are there. They are the game of the courts,
Nothing
my lord.
in the against the petitioner, Lordship. If it is there, Lordship.
In the objection, my lord, it was said that in one, not here, my lord, one of the several cases are there.
Not the petitioner is.
No, that is regarding present petitioner, sufficient material are there. No, can you please
My humble request,
yet to
Lordship,
be recovered.
any condition I will abide by, Lordship. Any condition may be given, Lordship. 53 days already, Lordship. They have got ample time to for my custodial interrogation, Lordship.
Some of them, yeah, that's why not.
Furthermore, Lordship, I am ready to appear before the IO, Lordship, as and when required, Lordship. Lordship, I have annexed the ticket, train ticket, and the purchase bill also, Lordship. I was in Kolkata, the petitioner number 2, Lordship. If this recovered from my godam also, then also, Lordship, the section of robbery that will not come against me, Lord. The recovery of stolen article will come, Lord. And 53 days, Lordship. With all respect, Lordship, kindly maybe the petitioner may be allowed to go. Permanent residence of Kamrup, maybe Kamrup rural.
We are saying that it was unloaded in the Quran of this.
Present petition number 2. The letter in the statement of government increase the list of them. On the serial list, 15 packets gray color bag containing 2 and white color plastic.
Yes, Lordship, that is in
This
the
one is good on
grounds of arrest also that is mentioned, Lordship.
statements are also. Appeal mechanism. Not very text is matter as section 3102 of credit matter. Before one subsection to this credit. Naturally, not at this.
Triple one lordship not attack lordship against the petitioner's lordship because earlier not succeeded.
Administrative. Then, administrative petition, state respondent. Application, sections, city receipt bills. Sir, Mr. Represent to it. And there was no recovery from the portion of the petition number 1. However, it is added that there are some recovery from the portion of the petition. But the day of incident, the petition number was not in the state of Assam, and he was in Kolkata. The next day only, he returned from Kolkata, and substantiate the same, some plain tickets of present respond number, sorry, petition number also. So but submit that the present accused petitioner are in custody since last 52 days, and thus I was opportunity to interrogate ready and willing to set their cooperation in further investigation this case. If they are done, it will be a job. That there are sufficient agreement matrix against the petition, and petition number was the driver by which all the petition number 1, sorry, petition number 1 was the driver of say vehicle where from all the state articles were loaded, and all those were kept in the godown of the petition number 2. Petition further it submitted that these petitioners are also involved in and from the considering the statement of the co-accused person and other materials available in the case diary, the prayer for prayer was made to prayer was made for adding section 10 subsection 2 BNS and 1112 subsection 2 BNS, which was accordingly allowed during the but it is submitted that from the other materials also it is seen that several cases are also been pending against the co-accused persons and accused petition, and accordingly considering the nature of the committed, this can be considered as an organized crime, wherein these petitioners, including the other co-accused persons, are Mr. Sharma further submitted that till date only 44 numbers of bags of pan masala, 14 bags of jarda are recovered from the person who accused petition number 2, but the rest of the materials are recovered by I. Next, in this context, Mr. Thakur, the learned counsel petitioner, submitted that it cannot be a case of any organized crime and section 1111 subsection can be added at this time. No charge is framed against an petitioner. Consider that this was an organized crime wherein these two petitioners were getting the submission made by an is dead, the materials is dead. You've seen that it revealed from the case that I was collected primitive materials against it and used petitions. And it is seen that these petitioners are also involved in a similar kind of offense, along with the some other co-accused persons. And considering the nature of offense, the prayer for adding section 310 subsection 2 was made, which was the considering all these aspects of this, the nature of offense and the phase of investigation and the further custodial investigation may be required to unearth some more facts in the present case. The kind is unfair. It only consider the time. Your petition stands.
Lordship, I was not present, Lordship. At least other sections, Lordship. Oblige, my lord.
May I please, your lordship? I am an interim lordship.
Yes, we have received here. Earlier you were on interim.
Yes, lordship.
Not
CD not received.
fine.
Charge is submitted.
Fine. Fine.
But it's the CS number.
Charge number 107 of 25.
107 of 25.
27 320.
27.
3 my
27 3.
my lord. 7 of 24.
Yes. 33724.
Oh, this is of
Well,
2024.
27 of 24.
25.
Well, taxi number 107 of 25.
Ah.
Dated 27 325.
Oh,
Much earlier it was submitted.
because it is a case of 2024.
Mile 24.
Subsequently, you were granted with bail on 14/11
Yes, lordship.
for interim.
Yes, lordship. Then after lordship, I have several time appeared the IO. Last time the court order dated lordship 22/1/2025. I have the again served the copy and I have the appeared lordship. And my record was
Because
statement
you
of
are
state.
cooperating.
Yes.
You are Mr.
Okay, that's
Mr. A.K. Das. You don't not. You don't. This next submitted and show that it's a already been transited by CS Thomas. In that context, Mr. Das submitted that the petitioners were on interim and in person to the interim order. They appeared several occasions before the considering then you are extending your interim for another 15 days so that you can appear with a regular bail and collect.
Okay.
May I please also? Petitioner for an interim, my lord.
Yes,
It is not receive, my lord. Here, after the he was called for along the statement of the victim, my lord.
Statement of the victim.
My lord.
Lordship, so far as my knowledge goes, my lord, I have in eco service, 2nd of September is the date of appearance in the lower court, my. As the charge sheet has already been submitted.
Date of already
Date of
charged.
appearance. 2nd September.
You have the information.
No.
Information, my lord? At 2, my lord.
Okay.
Yours. Public.
But the search is
Lordship, may pass over for timing, Lordship.
Sweet, the many matters are being timing. I don't know. Yes,
14.
yes, 14. Otherwise, you have received the case
My
there.
lord, case there receive, my lord, here FSL report come. Here it was, cause of death was not requirement, my lord. Therefore, it was sent for FSL. Fisher. But death report not. Petitioner number 2 is the interim, my lord. Present petitioner is the petitioner number 1 is the husband.
Who is the interim?
My lord, petitioner number 2 is an interim. So I don't sister.
I mean, the petition number 1 is the husband.
Husband.
Okay, then we are not keeping it as for timing, timing matter. Because we did the FSL report
Right.
and to petition number 2 interim, we will going to extend.
Lordship, petition number was not at the time of occurrence.
Who?
Petition number 1 was not.
He is the husband.
Yes, Lordship. Wow.
You cannot do anything.
Right.
He is the husband. Somehow we saw the considering this submission that petition number 2,
Two
the
was
sister-in-law, she was not there. That was considered, but one, how can you consider? He is the husband. Mr. Alam,
Yeah, along.
what used to be asked to done it also for the petition, also her petition concerns. It is submitted by Mr. Sharma that CD. Today you have received this.
My lord,
No, CD you have received today or?
no, earlier it was written the
CD was received earlier, which was retained. But though it was communicated with the IO, the FSL report could not be collected. Considering the case, CDB return, directing the investigating officer to furnish the updated case diary along with the FSL report. If collected, full stop. 11th September. 11th
from human.
from
Human.
11th of September. 11/9 and interim granted earlier to the petitioner number 2 be extended to the interim.
Fine.
Deep Lovelace.
Please, Your Lordship. The aim was still is on next month in court number 2. The hearing is going on, Lordship.
Because I mean, there are one matter is fixed at 2, yesterday only. So I don't know if all the matters are being timing that may not be at 2, we have already fixed a matter 2. And
Can it be
more
only for the
matters are
time
fixed
being,
at
Lordship,
2.
if it finishes?
Huh?
Oh, Lordship.
He is on interim.
We are on inter.
Once some report was called for by the IO from the public health. So it has been
What you have submitted?
some reports are yet to be received by the IO.
Regarding the
Reports.
authenticity of that one, the main issue is that regarding issue of a birth certificate.
Oh, acha.
Regarding the authenticity of that birth certificate, some report is called for by the higher from the office of the
Birth and death
Issuing
registry.
authority. So that has not been received.
But you have received the case diary. This is updated.
Yeah.
You want to retain it or what to do? Okay, Mr. Heard Mr. B. Chaudhary, the done it conflict. And also part Mr. B.S. Kaur, done it. So you know. And it is submitted by Mr. Sharma that the updated case diary is received, but this is the report is not yet received, which is to be collected from the concerned authority regarding the genuineness of the birth certificate. In view of this, the CDB detained till next set of listing. And then additional brief we will make communication, personal communication with the I to get the report from the concerned authority. Is the matter when can be? Because we are going to retain the case diary. So I don't know, Borwa will tell yet for tell it. Pardon? Can it be retained till 10th? Can it be? It can be. That
Even in date protection.
yes, no, that is otherwise because we are going to retain the case diary, that's what I am asking. 10th. But in the meantime, you make communication to get the report.
Okay.
Otherwise, same again, it will be same. So 10th of September, 10th of September for you. Interim be extended till next.
Deeply obliged.
May I please, your Lordship? Lordship, in this case,
Yes.
petitioners
Yes.
are on interim.
Yes, what is the position of
My CD not received.
CD not received?
Not received. Not.
Lordship, cognizance has been taken by the learned JFC, Bilasipara on,
Cognizant,
Cognizant,
yes, charge sheet has been submitted, Lordship, by,
has it already submitted,
yes, Lordship.
but we don't have any information, is it?
Minor. Have you any
Do
information?
you have the instruction of the number?
115, 2025.
Search number.
Yes,
Such number is
115 of 2025,
Dated.
dated 30/7/25,
37.
7.
After interim it has started.
That
Lordship,
means
case,
after your interim order, it has been.
yes,
Search number given 11
115, 2025,
115 25 dated
30/07/24. Lordship, further white order dated 6/8/25, learned JMFC Bilasipara has taken cognizance and issued notice to the petitioners. Case is fixed for appearance on 14/10/2025. Lordship may kindly,
What to do that?
minor.
Your interim we may extend.
Minor. Dispose of minor. Let them appear minor.
till
If
appearance,
your information is correct,
Yes.
then we'll reflect in the order in that way only,
yes, Lordship,
that you have the information.
yes.
And as per you, when cognizance taken, date of cognizance,
30/07/2025.
on that day
On that
cognizance has,
day.
no.
Uh,
CS is filed on 1/15/2020 30/07 and cognizance taken.
Cognizance 14/10 6/8/25. Sorry, 6/8/25.
6/8/25 cognizance taken.
Yes,
And your next date is
14/10/25. 14/10.
You are Mr.
S. Borhuya.
S. Borby.
Yes.
S. Borby.
On behalf of R. Bora.
Part Mr. S. Borby appearing on behalf of Mr. R. Bora. Done constitutive election. Also part Mr. B. Sharma. Done Mr. B. Appearing on behalf of It is submitted by Mr. Borby that as per instruction of the information, case has already been transited by CS number 115 of 25, dated 30/07/2020. And cognizance has already been taken on 6/8/2025, fixing date of appearance on 14/10. In view of this, the present petition is hereby disposed of with a direction to the appear before the learned trial court below with an appropriate application for regular bail, which may be considered in accordance with until 15 days to extend. We are extending your interim till 15 days from date of order. Within that period, you appear
Yeah.
with a regular bail.
Obliged.
What is 18?
Minor, CD not received minor, they are in interim minor.
It did not be extended. 18/9 can be 1/8.
Minor.
By listing it on 18/9, your
18.
interim will be
18.
मैं please your lordship.
position in 20.
Minor, 20 CD not received minor,
Again, you are on interim.
interim minor.
Interim में.
City not received. To reminder, then we extend till next. We are listing it on 18/9, your
Minor,
interim will be
18 minor. 18 9.
Highly obliged.
That's for you. That's for
May I please, Lordship?
yes.
Lordship, petitioner before your honor, Lordship, is in
We have
interim
received here case diary, no?
Permission. 20.
and he has appeared before the IO, is cooperated with the IO, Lordship.
In the investigation.
Lordship,
You were on interim.
Lordship, I am on interim, Lordship. FIR is at page 10, Lordship. May I read, Lord?
Yes.
Facts of the case of the informant is that on last 12/6/25 at night, the informant was sleeping on his own house. The accused number 1 illegally entered into her house, suddenly hugged her and committed sexual intercourse with her, taking advantage of her husband was talking to his old age mother in another house, since it was extreme court. Initially, the informant was
Formal.
Paragraph 6, my lord, I have stated everything.
Paragraph six.
Yes. Paragraph 6, page 8. Whole story is there, my. Some co-manager, my lord, mainly one Hikmat Ali, who is, and along with the FIR and accused person, they are already, my lord, they have been in custody, my lord. And page 9 is about the similarity of the name, my lord. Your lordship will find moreover, 6, 7 line. Moreover, the petitioner is not the named accused in the FIR, his father's name is so and so, and the accused who is named in the FIR, Asad Islam, his father's name is so and so. The petitioner believed that his rivals, by taking the advantage of the identical name with the FIR name accused, falsely implicated the petitioner in the instant case. And the petitioner is arrested only on suspicion. Nothing was also recovered from his house. Today 50 days, my lord. The further custody, supposing my lord, even then. And co-accused already get my lord in 30 days. Main matter after the your lordship's order, my lord, he was arrested. That is the basic thing. After your lordship's order is 3/4/25. Your lordship granted bail to the FIR named accused man. And he was arrested on 2/7/25 after 3 months. If there would have been anything, my lord, they could have been arrested during that period also. My lord. So after thought, whatever I mean to say, anyway, my lord, 50 days there, my lord, your lordship may consider on that now. If anything is there. Also, doesn't. Oh.
Approved the visit of 50 days of the state.
Yes.
60 days.
Yes.
My lord,
50 days. 50. He is arrested on 20, sorry, 2/7.
Here, a detailed my lord, investigation regarding my lord, a detailed syndicate, my lord, involved in cybercrime. My lord, a detailed cybercrime report is also available in the case there. My lord, I would just like to point out.
How 50 days?
My lord,
How 50 days?
my lord, your lordship will find
Arrested
61 is criminal conspiracy. And then 318 cheating, 3 years, my lord. 318 cheating, 7 years. That is what I'm saying.
My lord, I would just like to my lord, point out one statement of the accused, how this person has committed the offense. My
This
name-
accused or any other accused?
Yes, in other accused, but I will point out regarding
any.
present accused. My name and address is as true as mentioned above. I and Hekmat Ali Sarkar are neighbors. Hekmat Ali Sarkar opened a link, that is a link website, my website using my mobile number. Later, he activated my account through the serial number displayed on the website. I carried out through the website, which has been used, that website, used to lure and deceive innocent individuals by offering illegal financial schemes. So, my lord, I would first convince victims to invest money in the RSN cryptocurrency token by directing them to click on the website link. We promise them huge returns with a minimum investment of rupees 50,000. And through this scheme, we have misappropriated funds in the district. Initially, the victims were required to open wallets in apps like PhonePe or Paytm, where their bank accounts were linked. These wallets were used to buy US dollar tokens, USDT in bracket, through P2P transactions on Chinese company apps like Binance. These USDT would then be used on website to buy RSN crypto tokens. So my lord, these are very difficult to understand how they, my lord, initially get an account by taking the ID of the investors, my lord. Their accounts were linked in that website. Thereafter, my lord, on the pretext of buying cryptocurrency, they are lured to invest in sometimes also, my lord. Thereafter, my lord, those my lord, websites are unauthorized, my lord. Unauthorized website. Thereafter, when they invested those amounts, my lord, those accounts, my lord, immediately, my lord, by way of some, my lord, transactions, those they somehow, my lord, those investors' money were misappropriated by these accused persons, my lord. And thereafter, my lord, in addition, we were also involved in renting out or purchasing investors' bank accounts, renting out and purchasing investors' bank accounts. Previously, we had invested significant amounts in a similar cryptocurrency token, UBIT, which is no longer available and was shut down. We also used electronic means to send details of victim accounts to unknown persons. They also, my lord, send those victim accounts, my lord, to some unknown person who were lured with promises of rupees 1,000 to rupees 2,000 per account per month. I would also like to reveal that for every RSN investment made through the website, we took a 2% commission in the form of RSN tokens. These tokens were later sold and money was deposited in the linked bank account. So in this manner, my lord, they lured the investor, my lord, in this unauthorized, my lord, through these unauthorized investors, my lord, they invested money. And in this manner, they collected huge amount of money. And later on, my lord, when during investigation these accounts were, my lord, detected by the cybercrime investigation, and later on they came to know that those accounts were purchased, rented by some persons, and my lord, actual criminals were, my lord, ultimately it is difficult to find out those. These are the some of the my lord, way how they committed this type of. These are, my lord, network is, my lord, everywhere, my lord, not only, my lord, in the state, my lord, outside the state, in some international link is also there, my lord, in this commission of this type of offenses. Well, otherwise, regarding the present accused person, my lord, he is after arrest of the lodging of the FIR, my lord. This is the statement of the. One detailed, my lord, cybercrime investigation report is also available, my lord. Some terms, my lord, it will take some time to understand. Otherwise, my lord, it will be difficult. Yeah, 111 BNS is also there, organized crime, which is 90 days.
100
One of BNS 3183, 3184. Registered.
কতদিন হবে previous school নাকি ভিডিওটা লেখাই নাই POC 1112
1 1 one to problem ideas. 90 days. 90 days.
Triple one is added.
Yes, triple one is there.
Triple one is there, my lord.
Yes, there.
It says whoever
Not
commits
added, already
organized
there.
crime.
Already there, man.
My lord, you'll just time remind. Whoever commits organized crime, if such offense has resulted in the death of any person, be punished with death of life and shall also be liable to fine. If any other case, punished with a term which shall not be less than 5 years, which may extend to imprisonment for life. So ultimately, life is there, man, in both the cases. So 90 days, man.
Prepare some idea.
Yes, I
in the
do.
name of helping this in that commission
Yes, man.
by creating those ideas.
Yes.
First. And thus, and in one other person is Sipar is also there. Seems that he is from Mumbai.
But
These are definitely organized.
yes, organized crime. Man. And one Caesar list also is there from this Asadul, son of the present petitioner. Some bank accounts of mobile number, etc. of the present petitioner. See.
Yes, that is.
One, ultimately, we found that 111 is also a one. That is 90 days. So that part, I said I had 60 days, so I corrected my 90 days. So my question, my your lordship, I do not know subject to what your lordship has seen, my because he's to our information, my lord, after 3 months, my lord, he was. If there is anything, my lord, he could have been there, my lord. Your lordship can say FIR is dated 2/3/25. 2/3/25. And your lordship allowed them to go on board on 3/4/25. I am only on that, my lord. And he is arrested on 2/7/25. And that too, my lord, after the Panchayat election, my lord. And this person was involved in campaigning, my lord, so some that we have taken in our, my lord, in the petition also, my lord. Only then, my lord, when they found that the other person already got bail, so this person, my lord, they have got this similarity of name and ultimately my rivals. This is my case, subject to your lordship.
Otherwise, my lord, in item page number 25, your lordship on the ground of that is on different aspect. Your lordship has
Yes.
in that my learned senior also appeared. Asadul Islam is also
Yes,
there,
yes.
my lord.
One other.
Yes,
One
other 3
Asad.
persons, my lord.
So why again I will have to, my lord, got this identity, my lord, report? I do not know because Asadul Islam already granted bail by this honorable court, my lord.
After 3 months, well, this person.
Because that Asadul Islam is son of Abdul Sabur SK, my
My lord?
Because that Asadul was already there.
No, that person was there, my lord.
And then again you are.
No, I have not,
raised the
because
issue
that Asadul was,
regarding
he was involved, he is named in the FIR, my lord. So there is no question of raising that question, my lord. He is the person whose name appears in the FIR, my lord. Your lordship got my point, my lord. That Asadul Islam is the name, his name appears in the FIR. So there is no question of raising, my lord. He is the person whose name is there. This person, my lord, he is other than that Asadul Islam. That's what I'm saying. So in that case, my lord, this question does not arise, my lord. I should raise or not, because he is the person, my lord, he is there on the ground of my lord that.
Seen Mr. Botwood one Hekmat is the most notably main mastermind.
Yes, yes.
And this accused also to create all those leaks and all. And one earlier they were working on some other idea, I think that was closed, that website was, and thereafter he was engaged in preparing the other idea in for the commission he was doing. But these are, I think these are quite sharp in those things. but why they do not engage themselves in doing some other good work?
Yes.
Yesterday, I had seen before I think 2 3 areas are there where from they were just labor class people and all, but suddenly they buy the 4 billion car, 50,000 mobile, wristwatch, mobile and all that. Then only inquiry come that all these things they are involved in cyber
Cyber and
as
crypto.
well as the other.
Yes,
These three areas are there.
yes, yes,
Now they all are this kind of
yes, man.
coming
Yes.
up. This-
And day by day, my lord, increasing this type of open. Cyber.
Now the different things are coming up because of technological development. Man. Everybody is now, we are also victims sometimes. It happens, madam, but there are some cases where I find, madam. I'm not denying that these things are happening, madam. Anyway, madam, ultimately, madam, whether further custody is required, madam, so for this matter, that I lift your worship.
Separate IO's notice here, no.
Yes.
Notice here, no.
And no, my lord, first later
First page is
later part of the one detailed, my lord, cybercrime investigation report is there, man. That one booklet, man.
M. Hussein.
Sal. Different part. And Water is import
Yeah. So,
Satisfaction. This one is to good satisfaction.
my lord,
Satisfaction.
CGM South Salamaga, Mankacham. Obliged.
Yes, only about 30.
In charge principal, sorry,
Informant.
or informant. Also. Or the two objection filed, one by the informant, other by the in charge principal. And we have also filed our reply, my. Whole question, my your lordship, if you kindly see the your lordship, the page 20,
You have two objection means.
one by the informant,
Informant lordship,
one
one by the
the in charge principal.
In charge principal.
lordship.
So basically, my lord, I am the principal of the regular college, my lord. And interim was there, I have appeared, my statement already recorded, my lord. And fully I am cooperating, my lord. Everything documented, I just take to your lordship, page 25, my lord. Departmental suspension order, my lord, because reasons for that suspension was page 25. Sorry, 28, my lord. Page 28. After suspension, this so-called my statement of allegations are there, my. Your lordship got it, my.
You got suspended.
You were suspended, my lord. Suspension order is page 25. Page 25, suspension order. Twenty-eight, 125. So he has no access to the college, my lord. Your lordship, where the inquiry committee was constituted by so-and-so to inquire into the matter of financial irregularities, alleged to be committed by Sri Jaharali principal come so-and-so, from the inquiry committee comprising financial irregularities have been committed by the principal. Therefore, the undersigned So cause murder. Then you will file statement of allegations, page 28. What was the charge against me during the course of my lord that inquiry, my lord? Page 28. Page 28 and except 5. Your lodge a statement of allegation, my lord. A preliminary inquiry was conducted to investigate financial irregularities during your tenure as principal based on complaint letters received from the various sources of your college, including the president of governing body of the college. He is the main person against me, madam, all the time from since long while. Therefore, the findings of the inquiry indicate, your lordship, your complicity in the following allegations, and accordingly charges were framed against you. Observation regarding infrastructure development of so-and-so college for the year 17-18. On scrutiny of the records, it was observed that rupees 1 crore was sanctioned for infrastructure development of so college for the year 17-18 by the Director of Higher Education, Assam. The plan estimate of rupees 1 crore was prepared by the Assistant Executive Engineer, Building Subdivision, Barpeta. The TS for work was accorded by the Superintendent Engineer, PWD, Guwahati Building Circle by number so-and-so dated some 19/7/17. As such, you have submitted the utilization of one installment of 50 lakhs. But the final completion report duly signed by the technical person of the construction committee is not yet produced, which was subsequently produced, my lord. It appears at page 35. That about the remaining period, my lord. So you are hereby charged with misappropriation of government funds, gross misconduct, non-maintenance of official record. Now I take your lordship to page 35, my lord. Just then it will be clear, my lord. Page 35. Your lordship, this is from my lord. That is district subdivision engineer, my lord. This is to certify that infrastructure development of Uttar Bapata College, balance works of first floor and the ground floor of the RCC class building, interlocking concrete lock, college gate, etc., installation of so and so, so and so. I have completed. IT have been completed as per estimated values amounting to 1 crore as per installment basis by the so and so for the year 17-18 and as per technical sanction obtained from the competent authority. So the director is saying that by 50 I could not produce. He has not stated but he had misappropriated mine. So ultimately it was done in the 2 installment, but it was given my that utilization certificate. Page 32. It starts from 31 to page 32, your loss will find 25,000, etc. That's where it was given. Yes, sorry, 25 lakhs, etc. So it was given by installment utilization certificate, 25 lakhs, 25 lakhs, 50 lakhs, that way it was given. Now the question matter, they are saying that I have not handed over the charge, my documents, etc. And some of the documents are fake. That is, they have now come allegation, madam. And your lordship will find I have handed over my charge, your lordship long back. Your lordship will find that page handed over charge, my lord. Page. Reply affidavit, page 65 on 67, my lord. Last, we have submitted a reply, my lord. Written. 67, my lord. 65 to my lord, your lordship may onward. 65 onward. The reply affidavit. How long? The reply affidavit. It was filed as soon as date. Hmm? 16 to 8. 16-8 it was 5. 18-8. Presentation তো করে নাই নাকি? 18-8-25.
67.
My lord,
Page number
page
67.
number 69 you lost claim this one. 68-69. You start from 67 type copy, page 67.
These are all documents.
All document you have handed over, received page, next page, my lord, handwritten, your loss will find. Received on 22/2/25 by the in-charge principal. All these I have filed them. My now they are saying that my lord, these are the not the correct the document I have manufactured, etc. my lord. It was given at 22/2/25. And suspension is my lord from the date of 01/23.
Departmental proceeding going on, everything.
And department already, my lord, your lordship, they are saying 2 crores. Department especially saying that this is the thing. Certificate I have submitted, all are documentary evidence. I have appeared before the IO. I have given my full statement, my lord. Nothing remains to be, everything on documentary evidence. So I am now in suspension. So no access to the, my lord, official file, etc. my lord. So further DP is going on. So further, my lord, custodial interrogation is required. That is your lordship to kind this. I have never violated any condition, my lord, of the condition.
Lordship, in such, the accused already submitted some documents, is right, Lordship, but yet to be submitted some more important documents. On 2/4/2025, he himself, kindly see my objection, Lordship, page 55, Lordship.
Page
55, back of it, Lordship. 55. Fifty-five Lordship type copy and 56 Lordship original. The following documents still be pending. Still in his hand.
And it's a three. Presentation to Guru.
So you want this you have submitted, you want to say that those documents are yet to be submitted,
Lordship,
not yet submitted.
not yet. Sir. And the resolution has been taken on by the GB on 22/6, Lordship. Kindly see page 48, Lordship. 22/6/2025.
Page number, page. Page.
Page 48, Lordship.
Say, yeah. Figure 48, this is the resolution.
This is the resolution.
So what is this resolution? As per resolution, these are the copies.
yet to be
What,
submitted.
what resolution says what?
The following, may I read, Lordship?
Yes.
Today's meeting discussed quickly on the internal environment of the college or in entities running a provincialized college according to the rules and regulations. The first proposal of the meeting held on 13/3/2025 was decided to return entire original documents of the college and money of the college, which was unauthorizedly kept by the suspended principal, Mr. Jawahar Ali. However, in such principal, Mr. So-and-so said that Jawahar Ali has not refunded the imported essential documents and college money till till that, despite giving 3 notices. Instead of suspended principal, Mr. So-and-so has not responded responded to the Uttar Pradesh College Authority. The in-charge principal said that the college is in difficulty in running without documents. In this regard, today's meetings reviewed the burning issues and condemned the negligence actions of Mr. Zahar Ali, suspended principal, seized all the important documents for his personal interest. Therefore, today's meeting unanimously adopted a resolution to take immediate legal action to bring return all the important documents and money to the college account. Today's meetings also recorded the required documents list and money of the college account. Today's meeting also recorded, today's meeting also recorded the required documents list, which is prepared by the in-charge principal. The principal in IC and GB president is given the responsibility for taking appropriate action for the list. The required documents. Number one, proceeding books, CL number. Lordship.
And other three. As per your, the main objection is that in spite of his suspension and all.
Lordship, the GB resolution, GB resolution, one GB resolution taken by the on the main contents of the affair, Lordship.
Yes, where is the FI 30?
FI is page 18 to 24, Lordship.
Page 21.
A GB meeting is shown on 10/12/2023, which is actually held on 10/12/2022, which is mentioned in the last visual line T of first phase. The meeting was fortunately for manipulating and resolutions and submitted the Honorable Guwahati High Court and mentioned dated 10/12/2023. Actually, 10/12/2023, no meeting was held on. And in that regard, one member,
Just in the FI itself,
FI itself, Lordship.
it's point number 1.
Point number 1, Lordship.
Which is actually before the High Court, on what time it came earlier?
Oh,
Because
one
from-
WPC
from
was,
already the resolution submitted the government.
Lordship, the accused person, Lordship, the accused person has already filed a WPC before the Honorable Court for against the suspension order.
Oh, against the suspension
Order.
order filed.
Fine. Lordship. That the WPC has already been rejected, Lordship, Honorable Court.
He filed a
Highly, which was already
wherein-
rejected.
wherein those things it
Allow within
Lordship.
2 months.
actually, it was some false
False,
statement.
Lordship.
Yes, then
Lordship.
number two is also there.
Lordship.
See themselves have written in the proceedings. They sitting the signature and seal. Completely four signature was also four.
Signature was 4. Lordship, kindly see page number 22.
22.
22.
Hmm.
Pair number 3, serial number 3, Lordship.
Hmm.
Dr. Tapan Chandra Nath was not a member of the governing body on 10/12/2023. His signature is shown in the 4 numbers of the first page of the meeting of the governing body on held on 10/12/2023. The accused has scanned the sign and pasted. And this allegation already informed by Tapan Chandra Nath, Lordship, before the competent authority, that is the Director of Higher Education,
That has already been.
already been served. Under resolution number 6, which has been 6 of the proceeding book was not adopted any GB meeting of the college even on 10/12/2023. The resolution is completely false and fabricated. So, Lordship, the interim order as well as the welfare, Lordship, may be rejected, Lordship.
The proceeding book is also not original.
Not original.
Yes, sir.
My lord, here I have received the case diary, my lord. From the case diary, it reveals that my lord serious allegation against the ex-principal, my lord, Zahir Ali, Dr. Zahir Ali, my lord. As per my lord, FIR 2 crores misappropriated by the present petitioner, my lord. And my lord, here several witnesses examined, my lord. All the witnesses said that, my lord, he has, my lord, GB meeting, which was held on the so and so manner. It was wrongly manner given that their signatures also taken head signature manner without the any manner people who are not present at this stage, who was also not the member of the government governing body manner, their signatures also taken manner. And it was said that manner 2013 চনৰ পৰা মুঠ 1,90,00,000 গভৰ্ণমেণ্ট অডিট ৰিপৰ্টত অবজেকশ্যন কৰিছিল সেইখিনি জিবিএ ৰিজাল্ট পোৱা বুলি চহী দেখাইছে that is my lord main allegation and witnesses my lord here is the Tapan Chandra Nath my lord he was not the member of my lord governing body my lord but his name was shown in the and one my lord resolution number 6 was later incorporated my lord although in the general body meeting GB meeting it was not there. Resolution number 6 man that is
Okay. Resolution number 6 is
Mine.
also tempered.
mine. That is my lord main crux of that.
One minute. Mister? What is You already have it hopefully and this statement is really is granted with a privilege of Mr. But the reality is but but he already submitted something and it is still from that the money was and which was utilized and public because it he for listed the document on 20/02/2025. He handed over all the documents because what we did by it. But is understood no other created but documents cannot be bring with investigation. Yeah, all the documents which is basically based that there are some and appropriate and money showing to be based on 10/12/2020 the post is signature the nature is presence one a member of the governing body 40 is signature one resolution is one resolution was made. He further submitted that the assembly is ready. In spite of the return based by the respect and the product, he produced some false resolution before him, stating that the the objection is already made it up. Objection of misappropriation of 1 crore has already been resolved in the government and body. Thus, misappropriation and it the department it the forgery by and also committee for the signature of the members implement as well as
কোনটা লাগবে? কোনটা লাগবে?
stated that the effect itself, it seems that the petition also produced some wrong document before the court while the defense while filing a writ petition against the order of exception where he created a court document showing that the on TV was held on 10/12 by 14 and also claiming that his presence in the court meeting and are even after his suspension. Without it, but but the order of your earlier interim order stands vacated and your
Obliged.
I have filed one application for suspension of sentence that is pending, but matter has come up for hearing. It is a 2025 matter. So my prayer is that my IA may be taken up.
Yeah.
My IA for suspension of sentence may be taken up, Lord. Instead of taking the hearing, because it is a 25 matter, hearing may not be taken up.
We'll see to it whether I can be taken up or it can be, it may matter may reach, then
Yes. Okay.
May I please, Your Lordship? My Lord, I'll have to, Your Lordship had heard it many number of times, my Lord. I'll be very, very cryptic, my Lord. Yeah, my Lord. On the factual metrics, it's a, of course, PRS bail, my Lord. What is of much important, my Lord? So far as the FIR is concerned, I'll not read the FIR, my Lord. I have to have a pointless, my Lord. There, my Lord, I have been named only as a, my Lord, contractor. Contractor there, that is one part, my Lord. And secondly, my Lord, only one aspect I say, my Lord. I'll go to the, some authorities they have placed, my Lord. they are also in my favor. I'll place that, my lord. And the latest one that has come on 18th, my lord, that clarifies everything, and that is not pari curiam, my lord, because all the authorities have been discussed. And the prime point in a case of, my lord, this nature, my lord, earlier 306, my lord, with all respect, my lord, there has to be mens rea. The harasser for a long period doesn't make any difference. That doesn't tantamount to commission of that offense, my lord. There has to be mens rea that by my harassment she would commit suicide. And it has to be proximate, latest one, my lord. But I'll come to that. And they have placed some authorities, and their paragraphs also, my lord, it supports me possibly. My lord, this man is 70 years of age, my lord.
70.
Oh, not 70, my lord. 70 years of age, my lord. And secondly, he has been carrying out, my lord, with all respect, my lord, several projects since several years, my lord, and no blame is till date, my lord. And he had the last occasion of meeting this unfortunate lady, my lord, in the month of, there cannot be anything contrary in the case, in the month of, my lord, April 2024. April 2024, my lord, when she visited, my lord, his house, as because she may have joined recent that time, my lord, or other, from 24, no contact, my lord. With all respect, my lord. And he has a lot of disease and everything. These are besides the point, my lord. And another aspect, my lord, with all respect, my lord, but that suicide note, my lord, with all respect, my lord, that came into the public demand in whatever manner, my lord, with all respect, my lord, there my name is not, only, my lord, allegation is against possibly some, my lord, that who carried out the design part, my lord, with all, and there is no mention of corruption, my lord. That narrative has been created subsequently, my lord. There is no mention of corruption so far as I am concerned, or regarding any others also, possibly no mention, my lord, in the suicide note. No name, my lord, with all, my lord, with all respect, my lord. The only designer brave, my lord, with all respect, the suicide note, because in a case of suicide, anything if to be attributed, my lord, for what reason she died, that has to be attributed, my lord. And apart from that, assuming corruption would have been attributed, even in that event, my lord, I met her in 24. No mobile contact, nothing, my lord. Only that, my lord, that ingredients of 45 are to be completed, my lord. Those are, it cannot be under no circumstances, my lord. And assuming they create a narrative that, my lord, there is corruption, and in this government, my lord, as I do understand, my lord, as a student of the, my lord, law as well as, my lord, the current, my lord, situation, my lord, under this government, my lord, till date, my lord, with all respect, my lord, any project is entrusted, that is to be completed in time, my lord. And if there is any corruption, my lord, immediately, my lord, cases are registered and picked up. In this case, my lord, no sections of PCA and no allegation of PCA against him, my lord. And there cannot be any, my lord, mobile connection that either money was paid to her, or, my lord, that there was faulty design, or there was substandard material, that is with some, my lord, SDO, my lord. And there was no complaint from her. At that complaint part, police complaint and higher up complaint, my lord, I have not created it, my lord. Those are in three authorities of the apex court. Have I made my question clear, my lord? So in the suicide note, nothing is attributed to me. And with folded ends, I'll submit, my lord. 70 years of age, my lord, if, my lord, arrest is, Joginder Singh authority is clear, my lord. With all respect, my lord. Arrest is, even if it is possible, because non-bailable section of law cognizable, then even arrest is not to be carried out. That also one paragraph I'll read out, my lord. So if suicide note is gone, my lord. Thereafter, my lord, with all respect, my lord, 70 years of age, my lord, I have never possibly visited, because of my age, my lord, I have never even visited the site for many months, my lord. My officers and, my lord, my family members, they look after the job, my lord. If there is otherwise, people will contradict me, my lord. My lord, that I have stated, my lord, with all respect, my lord. And, my lord, one aspect, my lord, unfortunately, my lord, all these authorities talk about young girls, my lord. The sentimental value, my lord, the philosophy of law, as Krishna has rightly said, that authority I will not read, my lord, that my lord, philosophy of law is to be left to the legislature, my lord. They legislate. Had there been, my lord, with all respect, young age, lady has died, very unfortunate, my lord, I never say that she died, and that is why, my lord, then there has to be special provisions in the statute, like in the dowry prohibition and everything, my lord, that presumption and everything, my lord. Those are not here in the act, my lord. Now this creative, my lord, that she died, Whatever is contained in the suicide note, that is final, my lord. Apart from in investigation, if it comes out that there was corruption, then they'll have to add sections of corruption or register fresh cases, my lord. With all respect, that is also missing, my lord. At 70 years of man, my lord, case there is before your lordships. Lordship will kindly find out as to whether there are materials against him regarding corruption part of it, my lord. Otherwise, my lord, my prayer is, my lord, I'll press the authorities now, my lord, that let him be given interim. My lord, if there are materials of corruption, if they find out in the subsequent days also, let him be arrested. Otherwise, a 70-year-old man, because his name is not there, only contractor party is there, he'll be picked up and put behind bars like the others, my lord. That is possibly may not be necessary, and that is not the Indian criminal justice delivery system, my lord. And another aspect, my lord, with all respect, my lord. Again, I am repeating philosophy of law, sentimentality, all to be left to the legislature, my lord. Not the domain of my lord, defense and prosecution, my lord. And the latest authority, my lord, it has discussed everything, not par incuriam, my lord. All authorities have been discussed. That I'll read out, my lord, that had come out on 18th of this month, my lord. And thereafter, my lord, with all respect, my lord, that is covered by Article 143, my lord. The law laid down by the Supreme Court should be applicable to all courts, inclusive of prosecution and defense, my lord. Have I made my position clear, my lord? So far as the section of law is concerned, my lord. Now, my lord, with all respect, my lord, first I read, my lord, I'll be one paragraph, I'll be reading only, my lord. 70 years of age, lot of diseases, even some eye disease, my lord, that document, glaucoma or something, my lord. And he does not come to the site, my lord, with all respect, my lord. And my prayer is, my lord, diary is before your lordships. If I say, my lord, if after consideration, my lord, I don't favor absolute, my lord. Interim, let him appear, give his statements, and assuming lordship finds out materials in the case diary regarding corruption part of it, well, that is different, my lord. With all respect, my lord. That cannot be there, my lord. Now, my lord, with all respect, my lord, let me read the first authority, my lord, with all respect, my lord. That has come on. I'll be very cryptic, my lord. That is, my lord, Mohan Dhalkar, my lord. Mohan Dhalkar was an MP of Goa, Daman and Diu for 7 consecutive terms, my lord. For 7 consecutive terms, my lord. And this authority by the Honorable Chief Justice, my lord, and my lord, another puny judge, my lord, with all respect, my lord, it has discussed all the earlier, most of the earlier authorities, my lord. All authorities have been taken into account. And ratio of this case is, my lord, that whatever, my lord, I'll read that paragraph, whatever be the quantum of punishment, whatever be the duration of harassment, my lord. Here it is from 8-9 months, but no complaint. That's a different matter altogether, my lord. Harassment of petty tough, my lord, with all respect, my lord, toughest measure of harassment, my lord, toughest degree of harassment, my lord, and toughest duration of, huge duration of harassment, my lord, is not to be taken into account. Only 2 things are to be taken into account: the proximity of harassment and the date of commission of suicide, number 1, my lord. And secondly, my lord, these harassments, the mens rea has to be there, that by this harassment, that section 45 ingredients are to be completed, that I intend that by my harassments you would commit suicide, my lord. With all respect, my lord. So this, my lord, Dhalkar, that has come out on 18th of this month, my lord, 18/8, with all respect, my lord. I'll read it and place it before your lordships. On 18/8, my lord, 2025. There I read, my lord, para 22. I'll be very, very cryptic, my lord, and place it before your lordship. Para 20, a lot of paragraphs are there, my lord. This would be the possibly ratio, my lord. May I read it, my lord? All the earlier authorities have been discussed, my lord. That I will not go into, my lord. Pointless. Here, my lord, what comes out essentially from the various decisions herein before cited is that even if there is allegation of constant harassment continued over a long period, have I made my position clear, my lord? So far as the suicide note is concerned, whatever harassment, it is apparent, my lord. Not attributed to him, but if attributed to anybody, my lord, it is regarding the design part of it, and no corruption is there, my lord. With all respect, my lord. To bring in the ingredients of earlier 306, my lord, now the same, my lord, duplicated, replicated, my lord. With section 107, the 7 is 45 now, my lord. Still, there has to be proximate prior to act, clearly find, to be proximate prior act, to clearly find that the suicide was a direct consequence of such continuous harassment. Have I made my position clear, my lord? My last meeting was 24. There was no connection thereafter, my lord, with all respect, my lord. And assuming there would have been connection, my lord, there is no harassment, either mental or physical. No phone communication, no physical, my lord. It's all exactly tailor-made. The last proximate incident having finally driven the subject to the extreme step of taking one's life, my lord. Have I made my position clear, my lord? This is absolutely missing. And the same paragraph, my lord, last two lines. Merely because the victim was continuously harassed, as she has alleged, my lord, she was under stress for 8-9 months. I take it to be harassment, my lord. Supporting prosecution. At one point, he or she succumbed to the extreme act of taking her life cannot by itself resulting finding a positive instigation constituting abatement. Have I made my position clear? Even that harassment part is missing on my part. Thereafter, my lord, mens rea cannot be gleaned merely by what goes in the mind of the victim. Have I made my position clear, my lord? That I have mens rea by my harassment. There is no harassment on my part. Had there been harassment, even then, my lord, harassment itself would not do. That has to be proximate. 48 hours is the duration. And thereafter, my lord, on the top of it, there has to be mens rea. That by my harassment, it is in my mind that she would commit suicide. It is absolutely. Otherwise, my lord, I go to jail, I come out, that Joginder Singh, I'll read out, my lord, my image goes, and thereafter I got acquittal. So far as I am concerned, my lord, I am not meaning about the rest of the accused, my lord. With all respect. Now, my lord, para 23, very cryptic, my lord. The victim may have felt that there was no alternative or option but to take his life because of what another person did or said, which cannot lead to finding of mens rea and resulted abatement on the on that other person, meaning thereby me. What constitutes mens rea is the intention and purpose of the alleged perpetrator, inclusive of me, if any, my lord, as discernible from the conscious act, no conscious act, or words, no words, and the attendant no circumstances, which in all probability could lead to such an end. The result, the real intention of the accused, and whether he intended by his action at least to possibly drive the victim to suicide. I'll not go beyond, my lord, unnecessarily, my lord. Thereafter, last slide. However harsh or severe the harassment, unless there is a conscious deliberate intention. My lord, there is no harassment on my part and there cannot be any conscious deliberate intention, mens rea, that my act should lead to her committing suicide. There is no harassment on my part. 24, I last met her, I never visited. Have I made my position clear, my lord? And thereafter, my lord, conscious deliberate intention, mens rea is so far absolutely missing. Neither, my lord, proximate, no mens rea, no question of mens rea, it is not there altogether, so far as I am concerned, my lord. To drive another person to suicidal death, there cannot be a finding of abatement under section 306. Para 24, last, leaving aside 4 lines. Many stand up, some fight back, a few run away, and certain people crumble at times and take the extreme step of suicide. To put the blame on the pressure imposed and the person responsible for it. I'm not responsible. I never put any pressure. The engineers may have, may not have. Latif have perused the case diary, my lord. With all respect, my lord, at all times, without something more to clearly discern and intention would not be proper application of the penal provision of under section 306, now the present one, my lord. Meaning thereby arrest is not necessary, my lord. The attendant circum thereafter, my lord, with all respect, my lord, one more paragraph. 75, no? A2. Para 40, my lord, para 40, my lord. True, a person unable to bear the pressure or withstand the humiliation or unable to oppose. She was unable to oppose, unfortunately, my lord. May succumb to the extreme act of ending his life in desperation, but that would not necessarily mean that the alleged perpetrator had an intention to lead the victim to eventual death by his own or her own hands. Have I made my position clear, my lord? There is no harassment on my part, and on the top of it, these are to be completed, my lord, to fulfill the ingredients of both the sections of law, inclusive of abatement as defined in section 45, my lord. Thereafter, we find no such instigation on the part of the accused in this case, or a definitive abatement to suicide as alleged in the affair. Their allegation as alleged in the affair in the present case also, my lord. There arises a cloud on the suicide note. There is a cloud on the suicide note because of the reason, my lord, with all respect, my lord, that now, my lord, attendant circumstances have been included, my lord, attributed, my lord, that, my lord, somebody committing suicide, that is one of the reasons. Have I made my position? Those were the submissions, my lord, with all respect.
What is happening?
That, my lord, on the top of it, apart from whatever is there in the suicide note, my lord, another part is, my lord, corrupt practices on the lady forced by the, my lord, persons named in the affair. May not be me, my lord, but the engineers. Engineers are gone, my lord. So far as I am concerned, my lord, that I pressured her to do the job, those things are also missing, my lord. Have I made my position clear, my lord? And whatever, how see that, very unfortunate, my lord. In the suicide note, there is no mention of corruption. Have I made my position clear, my lord? That is my, as was submitted. And they place some authorities. I'll read those authorities, they support me, not their case, my lord. To one paragraph, my lord. This is the latest one, my lord, and it covers all the earlier authorities. Not all, my lord. Most of the earlier authorities, though it is not Parit Kuriam, my lord. This is one, my lord. And secondly, my lord, I'll be very cryptic, my lord. First is this, my lord. This is, my lord. This goes, my lord, 2025. Now, my lord, 2024, only one paragraph, my lord, para 37. There a woman committed suicide, my lord. With all respect, my lord. I'm reading, my lord, 30, 31, only 2 lines. Thereafter, I'll come to 37, my lord. This is reported in, my lord, with all respect, my lord. In 2024, SCC online, para 31, 30, 31, 32, 37. Regarding the this paragraph, I'll be very cryptic, my lord. As per the version of the complainant, there is the factual matrix of that case, my lord. 31. In the case of Sanjay Singh Sangar, this court, under the similar circumstances, has quashed the search sheet under section 306 of the IPC against the accused appellant. A factor that had weighed with the court in the said case was that there was a time gap of 48 hours. Have I proximity, my lord? Proximity is, mine is no proximity, not to talk of 48 hours, my lord. I met her once, cordial relationship in 24, my lord. I offered her gamusa because she joined, or my lord, she visited my house, my lord. Being the some officer in that, my lord, my construction, my business, my lord, it all official, my lord. And thereafter 32. In the case at hand, taking the allegation in the affair at face value, the incident that so-and-so, my lord, had occurred on 17 February 2015, while the deceased has committed suicide on 20th March. Have I made my position clear? My time gap is from 24th to the date of the unfortunate death, my lord. Now, what 37 says, that possibly would be the, my lord, ratio or whatever be it, my lord. 37. We further find that the prosecution has failed to prima facie establish that the appellants had any intent, in that case, too many, my lord, appellants, no any intention to instigate or aid or abet the deceased to commit suicide. It is missing so far as I am concerned, my lord. Had there been pressure from my side, no pressure. Even if there would have been pressure, my lord, then it would not have come within the ambit of abatement, my lord. Have I made my position clear, my lord? Crystal clear, my lord. No doubt that a young woman, like in this case, my lord, the sentimental, very unfortunate, my lord. No doubt that a young woman of 25 years, here a little bit more, my lord, has lost her life in an unfortunate incident. This is much more unfortunate, my lord. I totally agree. And this is, my lord, Article 1 covered by, stated by the Apex Court. I don't quote it, my lord. I quote only law, my lord. This is not my statement, my lord. Because my understanding of law would not do, my lord. Supreme Court's understanding of law would go, my lord. That is the law in India, my lord. However, in the absence of sufficient material to show that the appellants had intended by their words or acts, my lord, have I made my position clear, my lord? To push the deceased into such a position that she was left with no option but to commit suicide. Continuation of criminal proceeding against the appellant should result in an abuse. I'll not go and beyond it, my lord. When the case goes, why do I need to be arrested, my lord? With all respect, my lord. This is this, my lord. And thirdly, my lord, this was provided by my learned public prosecutor friend. My lord, the ratio of this case, my lord, it was placed during some paragraph. I'm thankful to them, my lord. Every, my lord, whatever we read, that I place, my lord. Here, my lord, 40 foot, it was submitted by the PP, my lord, on the earlier occasion. This is 2009. I'm reading para 19 only, my lord. The ratio is in my favor, my lord. Not in favor of the prosecution, my lord. One line I'll read, my lord. 19, Roman 2, my lord. Because the ratio would go, my lord. Obiter would not go. What is the ratio? Their case. It is in my favor, possibly, my lord. 19, Roman 2, my lord. That the accused had the intention to provoke, urge, or encourage the deceased to commit suicide while acting in the manner noted above. Undoubtedly, presence of mens rea. Have I made my position clear? Mens rea is the necessary concomitant of investigation. There, My lord, anybody, I'm not talking about this case, my lord, even conforming to the ingredients of, my lord, fulfilling the ingredients of 45, that would not suffice. Apart from that, this authority would prevail, my lord. There has to be mens rea. Have I made my point? A guilty mind has to be there. In a old man of 70 years meeting her in 24, what mens rea would be there, my lord? Assuming there was some ill behavior, ill motive, assuming no corruption here, my lord, assuming corruption, she ends her life. Would it lead to, my lord, mens rea? Would it lead to, my lord, proximity? No, with all respect, my lord. This is his authority. I'm reading out, my lord. There is another authority placed by him, my lord. I'll take 1 minute. This is, my lord, another PP. This is, my lord, 2017, Pawan Kumar, my lord. Paragraph, para 1 I am reading. They are also a young girl, my lord. So sentimentality with unfortunate, my lord. This is 2017, 7 SCC, my lord. Pawan Kumar, cited by my learned friend, my lord. There I am reading para 1. Only first line to show that there also young life, lost, my lord, lady's life, my lord. The present appeal by special leave depicts the sorrowful story of a young girl in the middle of her teens. Have I made my position clear, my lord? Goes. Thereafter, my lord, go to paragraph, so 43, my lord. Bro. 1, 3, 43. 1, 3 nalage niki. 3, 2. 3, 2 nalage. 43 I am reading, my lord, with all respect, my lord, the ratio. It was provided by him, my lord. 43. Keeping in view the aforesaid legal position, whatever was discussed earlier, my lord, in this authority, we are required to address whether there has been abatement in committing suicide. Be it clearly stated, mere allegation of harassment without any positive action in proxy. There has to be positive action, my lord. There is nothing on my part. And proximate, my lord, no proximity. There is no incident so far as I am concerned. Have I made my position clear, my lord, of harassment? In time of occurrence on the part of the accused that led to a person to commit suicide, a conviction cannot, when a conviction cannot be sustained, is arrest necessary, my lord? Because Article 21 will prevail, my lord. No person shall be deprived of his life and liberty except according to the procedure established by law. This is the procedure established by law. Then I'll go to Joginder Singh, my lord. 1 paragraph. This is his authority, my lord, I have placed. Another 2 authorities were placed, my lord, with all respect, my lord, by my friend, my lord. He was right, my lord. The ratio is this possibly kuntu informated here.
19.
This is, my lord, 2019 by my friend, my lord, informant side. There I am reading. I'll be very cryptic, my lord. They are also a young lady, my lord. They are also a young lady, my lord. I'm reading 16. Only 16 I'm reading. Rest I'll not go, my lord. It will be taking time, my lord. There also the lady is young, my lord, pretty young. Unfortunately, she had to commit suicide. Very unfortunate. 16 lordship may have found, my lord. In cases of alleged abatement of suicide, there must be a proof of direct or indirect acts.
Just a second, which one you're reading?
Para 16, my
No,
lord.
no, Joginder.
No, not Joginder, my lord.
1917.
2000, I'm sorry, my lord. I'm a fool this one again.
No.
Sorry.
You're right, he is signing.
I'm sorry. No.
Okay. It's okay.
My lord, 2019,
Yes.
my lord, there, para 16, my lord. Would kindly have a look, my lord.
Yes.
My lord, in cases of alleged abatement of suicide, there must be a proof of direct or indirect acts. So far as I am concerned, this man, my lord, 70, no direct. There is no indirect also, my lord, that over mobile or anything. Have I made my position clear, my lord? Of incitement that you commit suicide. Have I made my ingredients of 45, my lord? 1, to the commission of suicide. It could hardly be disputed that a question of a cause of a suicide, particularly in the context of an offense of abatement of suicide, remains a vexed one. Very true, my lord. The circumstances of attending circumstances are to be looked into. If looked into, it is in my favor, my lord. Last meeting 24. Next one. Involving multifaceted and complex attributes of human behavior and response reactions. In the case of accusation for abatement of suicide, the court would be looking for cogent and convincing proof, not mere allegation, my lord. Have I made my position clear, my lord? Proof of the acts, plural acts of incitement. My lord, can it be there, my lord? Absolutely not. Neither in the affair nor in the suicide note, my lord, or under attending circumstances to the commission of suicide. In the case of suicide, mere allegation of harassment. Have I made my position clear, my lord? I'll not go beyond it. Of the deceased by another person would not suffice unless there be such section on the part of the accused which compels the person to commit suicide. Everything missing, my lord, tailor-made. And such an offending action ought to be proximate on time of occurrence. First of all, my lord, as a student of law, what I do understand, my lord, in a case of, it's a very bad act, my lord, it should not have happened. Nobody would condone it, my lord. But the philosophy, my lord, the sentimental part, all young ladies, my lord, should not happen. But why it happens, that's a, my lord, it will open the Pandora's box. Nobody can answer, my lord. But first of all, my lord, what is the, my lord, philosophy of law and the legality of law, my lord? Two things are paramount so far as abatement in commission of suicide is concerned, my lord. First, there has to be mens rea, that I harass you for a long period, harassment of the highest degree, my lord, that would not suffice. That my harassment, in my case, there is no harassment, my lord. Assuming a man has harassment and he has harassment of the highest degree by words, means, mouth, physical harassment, and thereafter long duration, my lord. Have I made my position clear, my lord? If she or he commits suicide, the offense should not be complete, my lord. There has to be mens rea that my harassment, huge quantum of harassment, and huge duration of harassment, my lord. Long period I have harassed. I must have the intention, my lord, that my harassment, huge quantum of harassment, and long duration of harassment, I harassed him or her, my lord, would lead her to commit suicide, my lord. Can it be in the present attending circumstances, my lord? Possibly no. So these two ingredients, if incomplete, at least that section of law cannot be applicable, my lord. When it is at the end of trial, it cannot be applicable. At the question of personal liberty, my lord, it cannot be applicable now, my lord. And the last line, whether a person has abated in the commission of suicide by another or not, to only be gathered from the facts and circumstances of the case. What are the facts and circumstances of the case? That is, my lord, with all respect, my lord, exemplified in the suicide note, my lord. Have I made my position clear, my lord? And thereafter, my lord, my lord, one paragraph I am reading out. With folded answer, I submit, my lord. Lordship would peruse the case that he at leisure. 70 years of man, my lord. Diseases, my lord. He has several sites. And one aspect, my lord, my friend will have to agree also, my lord. Under this government, my lord, because these projects are all pilot projects, my lord. Prior to election, my lord, that it has to be completed in a fixed period of time, my lord. That, what you call it, but a mini stadium or stadium, my lord. So quality, my lord, some allegation here and there. If, my lord, money is misappropriated, pocketed illegality, my lord, no government, this government will not lie low, my lord. Have I made my position clear, my lord? Nothing has been attributed, neither in the suicide note. Have I made my, that's the end of the matter. Attending circumstances they create, undo, and if there are materials, my lord, I cannot bring TV, my lord, whatever is said before your lordships. The present executive engineer has exonerated all the others, my earlier ones, my lord. That is pointless. Had there been material, my lord, there would have been immediately by now an Azahar regarding, my lord, defalcation and everything, my lord. Sentimentality won't go, my lord. The legality would go and the factual metrics would go. This does not, government, in my knowledge as a humble student of law and the present circumstances, my lord, does not allow illegalities in acts in public constructions, my lord. Have I made my position clear, my lord? There is no allegation. Now, Joginder Singh, my lord, 70 years of mange. My employees look after it. I cannot even, because I have one eye problem. It is not that I am blind. I can look here and there, my lord. But only thing, my lord, eyesight is limited, my lord. Have I made my position clear? So works are now being carried out by children and, my lord, employees, my lord. Huge employees, several projects we have completed, my lord. With all respect, over the years, my lord, with all respect. Now, my lord, Joginder Singh, I am reading out, my lord, because this is an Article 141 authority. It is on the top of 41, my lord. 41 talks about presently 35(3), my lord. 7 years. Here, blanket, my lord. Have I made my position clear, my lord? I'm just reading out one paragraph and thereafter, with all respect, my lord. Page 268, my lord. Below, my lord, it is in between, my lord. Second last page, my lord.
Yes.
The lordship has found, my lord. The above guide, I'm not reading the guidelines, my lord. That is pro defense, my lord. The above guidelines are mere incidents of personal liberty guaranteed under the Constitution of India. No arrest can be made because it is lawful for the police officer to do so. What line this signifies, my lord? Because cognizable offense and non-bailable offense. So you arrest first, investigate thereafter. No, my lord. This line is, my lord, cardinal principles, my lord, of Indian criminal jurisprudence. India is not a banana republic, my lord. There is a constitution, statutes, my lord. This line is very important, my lord. No arrest can be made because it is lawful for the police officer to do so. Because the police officer can definitely arrest me. That's why I'm seeking pre-arrest bail. What the Assam police does, not like Central Bureau of Investigation, they arrest first, investigation thereafter. My reputation and everything goes, my lord. 70 years of my sickness, have I made my position clear, my lord? Kindly see, my lord, thereafter. The existence of the power to arrest is one thing. So beautifully and succinctly said, my lord. The justification for the exercise of it is quite another. Have I made my position clear, my lord? It is in the domain of the police officer. He has to be upright and state. No political interference. No arrest first. These two lines, my lord. No arrest can be made because it is lawful for the police officer to do so. The existence of the power to arrest is one thing. The justification for the exercise of it is quite another. Thereafter, my lord, the police officer must be able to justify the arrest apart from his power to do so, my lord. Merely writing it won't do, my lord. There has to be many pages in the case diary by way of adducing evidence, my lord, collecting evidence. Have I made my position clear? Not hearsay, my lord. Direct power to do so. Arrest and detention in police lockup of a person can cause incalculable harm to the reputation and self-esteem of a person. 70 years of age, no black spot, my lord, disease. Unfortunately, I took this thika, my lord. Otherwise, I would not have been here. That is his, my lord, with tears he says. No arrest can be made in a routine manner on a mere allegation of commission of an offense made against a person. Have I made my position, my lord? Thereafter, it goes on and on, my lord, with all respect, my lord. There would be, their second line be, it would be prudent for a police officer in the interest of protection of the constitutional rights of a citizen and perhaps in his own interest. Nobody moves, my lord. If somebody moves, my lord, have I made my position clear, my lord? In interest, fines, my lord, arrest should be made without a reasonable satisfaction reached after some investigation as to genuineness and bona fide of a complaint and a reasonable belief both as to the person's complicity and even so as to the need to effect arrest, my lord. Have I made my position clear, my lord? This is it, my lord. Now, my lord, my respectful prayer is this. Definitely they would oppose, they have a right to let them oppose, my lord. And see, my lord, I possibly stand on a different footing, my lord. My lord, heavens will not fall. Because whatever matters, lordship would at leisure find out. But my lord, corruption part of it, I'm sorry, my lord. Abatement part of it cannot be attributed to me. No mobile connection, no physical connection. That is gone, my lord. If there are other attendant materials, because those sections of law are not attributed to the case, my lord. Have I made my position clear? I mean, false narrative would be created, sentimentality would be created. Yes, young girl has, but who would say it is good, my lord? Only thing, my lord, I do not say that he be, if possible, lordship do decide whether I should get, I should not get. My age is a factor, sickness is a factor, my non-involvement is a factor, my lord. At this stage, I only pray, my lord, grant me the privilege, if possible, my lord, upon perusal of case diary. Interim, my lord, and if during meanwhile, my lord, police finds out, my lord, with all respect, my lord, other materials regarding my complicity, regarding commission of some other offences under several other sections of the BNS or any other law for the time being enforced in India, my lord. Let me appear, lordship would have, my lord, the consequences will follow. Have I made my position clear, my lord? This is my case, with all respect and full reverence.
Please, Your Lordship. Regarding first point that I will oppose, I have the right to. It is not. I will oppose on the basis of the materials available on record and on the basis of the facts and circumstances in present case, whatever material available before me. And regarding, my lord, the first argument regarding that suicide notice. On that day, my lord, my learned friend, my lord, appearing on behalf of the informant, clearly points out regarding one word that is used, that mental state. That he rightly pointed out that at that point of time he cannot take help of any, my lord, legal consultant. before my lord committing the offense of my lord suicide. That this should be the word, my lord, and because she used at that point of time those words, then those words come under the ingredients of the purview of the my lord, the offense that is committing my lord of abatement. So, my lord, the words regarding mental stress is there, and thereafter materials available on record how these persons, my lord, regarding the contractor also, my lord, in the suicide note, my lord, he specifically mentioned, my lord, not only those naming those engineers, but name of the contractor she also there in the suicide note. And now during making on that day, my lord, already I have pointed out regarding every time of arguing that matter, my lord, some of the materials available in respect of the, my lord, the present petitioner also. And regarding that, my lord, proximity mens rea, I will point out to your lordship that the present petitioner has not in contact since the month of April with the, my lord, deceased. That is not at all, my lord, true. From the records, my lord, it reveals that, my lord, your lordship may kindly the argument is that the family members were looking after the contract agreement of the, my lord, state with the, my lord, petitioner, my lord, that petitioner is entrusted to execute the contract and only sole responsible person. But however, here there are, my lord, WhatsApp contact, my lord, there are, my lord, some during investigation and from the analysis, the WhatsApps are there are communication. Yes. None of the present petitioner is also in contact with the, my lord, deceased, and my lord, regarding that aspect also there are some continuously pressurizing her regarding site approval. Regarding that aspect also, my lord, there are some materials. And regarding that whether offense should be complete, my lord. Your lordship, my lord, one thing, my lord, that this is the case, the present case investigation is going on, my lord. Already some of the materials, WhatsApps are, my lord, voicemail messages, everything collected by the police. In some cases, my lord, that those, my lord, FSL report yet to be, my lord, thereafter to retrieve those, my lord, emails, although those are present, that we have not yet received by the investigation. And regarding the involvement of the present petitioner, my lord, direct and whether there is any mens rea or not, my lord, I will point out from the materials available on record regarding the considering the present facts and circumstances of the case. In all those Supreme Court judgments, my lord, this is not a case of, my lord, interpersonal dispute. This is totally a, my lord, exceptional case. Here, my lord, the case is, my lord, regarding my lord, one young, already, my lord, word used that, my lord, one young, my lord, junior engineer, he has committed under what? Because of unbearable, my lord, mental torture by this person. For, my lord, for what, my lord? For preparation of, my lord, bill and for submission of bill. And without, my lord, what they have done while executing that contract, my lord, there are some terms and conditions for execution of the contract with the contractor by and the state, my lord. And all this during investigation, my lord, police has also collected, my lord, at the time of, my lord, executing the agreement, what materials should be used, what should be, my lord, how he has to execute the contract, everything is there, my lord. But from all these, my lord, conditions of the agreement, he defies, as because the present deceased, my lord, he from since, my lord, inception, since earlier, my lord, he objected to it, and because of his her objection, my lord, ultimately, my lord, how these accused persons, my lord, the contractor along with the engineers, my lord, continuously, my lord, providing mental harassment. And, my lord, mens rea of the present, why corruption will not come in this case? That may be, my lord, corruption is one of the cause in this case. Mens rea of these accused persons is, my lord, mens rea, guilty mind, my lord, motive is clear, my lord. Motive is because that, my lord, this assistant, because of the objection of this assistant engineer, they failed to get, my lord, approval regarding the, my lord, some of the, my lord, contractual work. So for approving those contractual work, my lord, he, along with the engineers, my lord, continuously harassed the, my lord, victim, my lord, and ultimately he forced to take this step, my lord. There are materials to suggest them. There are continuous, my lord, regarding that aspect. My lord, there are continuous, my lord, communication between the, my lord, friends, relatives, my lord. There are statements regarding that till before the day of the, my lord, incident. And which itself, my lord, from the materials, my lord, proves the proximity, my lord, that how she has been continuously suffering, my lord, and on the previous day also, my lord, there are communication, my lord.
With me? No. No WhatsApp with me. Lordship would produce the case diary. I've never in my lifetime. With my relatives, my juniors,
No,
work
no,
on
I'm
it.
not saying that with
The-
the petitioner.
With the petitioner, then my
With the
lord,
petitioner,
it has to be attributed to
At
me.
this point of time, my lord, that the son of the present, my lord,
Son may be hold up.
present petitioner and the petitioner, there are whatever, not on the previous day, but my lord, there are continuous contact, there are materials, my lord. Maybe
Whether
not
with
in the
me or
previous
not,
day.
my lord, Lordship would kindly pinpoint and ask. With me.
Yes, with the
With the deceased
petitioner,
and me, my lord.
deceased and the present petitioner and the son of the deceased, and the son of the present petitioner.
Whether regarding my lord, regarding corruption, my lord, or regarding putting pressure on her, my lord.
Yes, regarding putting pressure.
Well, that may be, my lord, 65 be supported. Lordship would produce those statements, my lord. Whether I am there or not, my lord.
And regarding my lord,
Those are, my lord, mayor saying on to kindly peruse the case diary to that effect, my lord. Whether I communicated, my son communicates, my lord. He's a site engineer.
Yes, he's
Have I
fine.
made my position clear, my lord? Son is different, my lord. I am the father. I do not look after. In the terms and condition that I am to look after only, that is not my employees and my relatives, my lord. They look after the job. With them, there may be telephonic conversation, WhatsApp also. So far as I am concerned, not there. Me putting pressure with my words, my lord. Have I made my position clear, my lord? In conference in my office, it is somebody is hearing, that is not me, my lord. Directly against me, my lord, supported by 65P. Not there, my lord. Lordship, but kindly peruse it. Have I made my position clear? My son communicating, it is not vicarious liability in criminal law, my lord. And there is no, my condition may be, my lord, contract may be terminated. Nobody will take up the contract. How it was given to me, that story I'm not necessary to tell at this stage. They cannot complete projects, my lord. So these are entrusted to all contractors, my lord, having a good record, my lord. Now, my lord, corruption part of it. Is there anything in those conversations that I paid her money or I demanded money? Please, I'll pay you this much of money. With my son, it is there. It is not there, 100%. That I'll pay you money, do this. These things are there or not. Mere communication won't do, because construction work is going on. Officers of the construction company will talk to the engineers, my lord. Am I correct or not? With me, there is no communication, my lord.
my lord, your lordship, the continuous, one thing is admitted that his son is in direct to me in continuous connection with the victim disease.
Oh.
And that is admitted.
My son may be arrested,
Yes,
my lord.
that is admitted. That regarding his son, my lord, and regarding that aspect, my lord, there are materials, my lord, and police yet to, my lord, retrieve those.
1 month, my lord.
Police yet to retrieve those, my lord, WhatsApp communications. And regarding, and your lordship may kindly one another aspect. This is, my lord, your case is, my lord, still investigation is going on. At the stage of, my lord, investigation, your lordship is not required to, my lord, meticulous consideration of all these materials. There are still, the present petitioner is not yet apprehended by his custodial interrogation will reveal, my lord, everything, my lord, his connections. My lord. And my lord, for that, my lord, his custodial interrogation is necessary considering the facts and circumstances of the present case, my lord, and his custodial interrogation will, my lord, ultimately reveal regarding all these aspects, my lord, his connections, his continuous pressure, everything, for which his custodial interrogation is, my lord, necessary.
My lord, Juvinder Singh is there to prevent this, my lord.
And regarding the present, my lord, Supreme Court decision, my lord, I would just like to point out one line of the recent Supreme Court decision. Fact of that case itself, my lord, to regarding that MP suicide case.
That is landmark because he was MP, he complained to the privilege committee also, my lord. And 8 times. Despite that, he committed suicide. The stress and mental pressure, my lord.
In the present case, my lord, immediately, my lord, when the dead body of the suicide note was recovered on the same day, when the, my lord, the victim committed suicide. And here in this case, your lordship may kindly come to paragraph 40, last paragraph, my lord. Why this case, my facts and circumstances.
40. I read out, my lord.
True, a person unable to bear the pressure or withstand a humiliation or unable to oppose, my lord, may succumb to the extreme act of ending his own life in desperation. But that would not necessarily mean that the alleged perpetrator had an intention to lead the victim to eventual death by his own or her hands. Next part, my lord. We find no such instigation on the part of the accused in this case or a definitive abatement to suicide. alleged in the affair, there arises a cloud on the suicide note. Here, this is important. When looking at the admitted statements recorded in the proceedings of the Committee of Privileges and also the manner in which the note was introduced in the case, here the suicide note was introduced later, not on the when the dead boy, when he committed suicide on that day, in the present case, that is cited by another senior, that in that case, here in this case, a totally different case. Here on the same day itself, suicide note was recovered. Here subsequently that suicide note was placed.
Okay.
In the before the Committee of Privileges, no reference was made to the various allegations in the suicide note against the named officer. We have found the suicide note is suspect, and we are not convinced that there is any modicum of material in the case to find abatement of suicide. So, my lord, here in this case, why that suicide note was, my lord, comes under the purview of suspect, because that suicide note was subsequently, my lord, produced in this case. At the time of filing FIR, my lord, that suicide note was not there, my lord.
My lord, I'll just say at one line, in this suicide note, whether anything is attributed to me, we do not say this suicide note is false, fake, or clouded, my lord. Even if not clouded, does this suicide note implicate me regarding abatement in commission of suicide or in indulging in corruption, my lord? Me, my lord.
My lord, the statement, one another as well, I just like to one relevant question. The statement, that is, my lord, paragraph 37, my lord, not only suicide note. 37, my lord, where the question of suicide note, my lord, only comes into, my lord. So, my lord, I am pointing out the suicide note is not only the, my lord, the statements recorded, the suicide note, for which there is a
paragraph?
Paragraph 37, last portion.
37?
My lord, last portion, my lord, 37, my lord. Next page. 1, 2, 3, 4. 8th line, my lord, 8, 9, 10. Despite our anxious reading and rereading, the complaints made, the statements recorded, the suicide note, over which there is a cloud, and the subsequent conduct of the police regarding the delay in registering a crime, and the casual statements made in the FIR, persuade us to negate the contention that the allegation level of direct. But here, that is not the case, man. Here, my lord, FIR is lost, my lord. Immediately thereafter, statements recorded, suicide note is there, my lord. And
It further
immediately-
strengthens my case, my lord.
And
Defense
regarding
case.
delay of
These
the
lines,
crime,
my lord.
on entire fact is different, my lord. Regarding my lord, the elements of mens rea and my lord, mens rea, that is not a new concept, my. Once again reiterated in this judgment, which was earlier, my lord, pointed there, I pointed out to your lord. And the, my lord, paragraph which supported my case, that also I pointed out.
My lord, these lines possibly supports me, my lord.
Regarding mens rea, my lord, it is not a new concept. For my lord, affecting the offense of the, my lord, abatement, my lord. Mens rea, guilty mind, motive, my lord. And here, my lord, from the facts and circumstances of the case, how, my lord, link of, my lord, corruption, how they pressurize to, my lord, approve their bill, and there is, my lord, statements, how his, my lord, her continuous contact with the family members, her relative, and proximity. Proximity is also, my lord, proximity is not that, my lord, with
Okay. Yes. Yes.
of whether the authority is not only in their mind, the ratio is in their only person applicable to that thing. That is misunderstanding of law. That is not to be done. That is in there. And in my paragraph, that was within the demo. There are seven that I think how the as here that is true. But for that complete in my law, that is why it is never get my question clear. Oh, my undue advantage, oh, you did take some. Why when my question clear? Another aspect, if like this, reduce the diary. My lord, in criminal justice judgment is there. Of any republic, my lord, but there is a constitutional my lord. Okay, my lord, then all respect, my lord, whatever is there, presumption won't go. That next, whether it's available or not, communication regarding suicide note is everything. I'm not saying everything. Investigation is different. If the suicide note is detailed people. And secondly, what I'm saying, fellow, that this authority has without fellow. Otherwise, it could be within this kind of whatever of authority this says this court may not be applicable only to this case only, not be applicable to other. That disclaimer would have been there. Secondly, I never wrote anything I stated. Now I mistake there. Only my application in 24 because the proximity NCI is the authority. And saying my law that it has to become higher up, won't do my law. It has to be by way of evidence. Narrative has been created regarding corruption. How much amount paid, how much did pass? Have I made my question clear, my lord? Is there any my lord, that day your submission was made regarding police complaint and complaint to higher authority? I don't think my lord, those three authorities I not read out. I do not make law, I quote law. In those three authorities, it is not there. DD committing suicide, she without complaint prior hand. I don't to put it for I don't I understanding of Supreme Court understanding your logic understanding. Here it has been verified by law. If there is a harassment of law violation earlier or if there is any another day I delete it. It is apparent that the higher up complaints are to be made irrespective of committing suicide. Or to be missing. And what this authority has said, the authority read 14%. It has been said, what is the ratio? Otherwise, no ratio would have been there. It's not a banana republic, my lord. The position of stated in Article 141, the law in the court can be applicable to all courts, court the territory of India. I said it, my lord, the ECF state, my lord, inclusive of cannot have. Visit before you evidence, my lord. Because of my age, I do not do that. If legal consent, I contact there is a clause. There is no clause. The understand on me, my lord. Nobody else can complain. That time terrorist interested, my lord. So many things are there. Does he knows? My bills are pending, my lord. I suffer either way. 70 years, my lord, I am what I am saying. All respect and put the hands. What's it may decide, I'll be highly paid. Another way, what's it? But 70 years of this. That is the subject matter. Whether assuming it is there, whether my role is specified.
Okay.
There is still one message and that supported by giving it a stage of my dear member, if possible. I'll appear and if there are material that fellow I communicated, I put pressure regarding this law attributed my law. And if there is sort of only a I have got the
Yes, you have received the. You already got the information. I think. Yes, submitted. Huh? CS number. P Bora, RMS P Bora. So you were on interim. So we are we are extending your interim till next date. Next date is on 2nd of September. Yes, that can be extended up to 2nd September. We are extending. It is order submitted by MS Bora that case is fixed on for appearance on 2nd of September. In view of this, the interim granted dated so and so be extended till 2nd of September. Free FI. In first FI, you were granted with interim. Yes. $50, $52. Yes. This is the FI in connection with the present case or no? Hmm. Right? Yes. In the second FI. Case 50. 5. Yes. But this information was provided while you got arrested in second FIR because Chanmari PS is there. But you got the benefit. You have already granted bail on the very day you got arrested. No, you were on anticipatory in some one case. In first FI, you were on anticipatory. In the second FI, but there in the this. Yes. One more case, the Chanmani PS. No, I'm on that. The question is that is the mention has been made regarding the penalty of one more. But you have already got the benefit of your bail, I think. Yes. Well, what is written here? Okay, is your are is the person was in relation to you or yes, Mohidul Islam. But is there any agent, any relation? order or judgment was passed prior to implementation of BNSS or there, because how? Because this order is of, pardon? Oh, it's 21, 125. Again from in Satindra Kumar until this case is again from Satindra Kumar until. Oh, acha. This direction was on 21, 125. That's why I'm just asking why BNSS is also there. Okay. BNSS. Below noted accused person who is your relative. Page 12. This is the forwarding report of Chanmari or Nunmati. Then accepted. 54. Where is any division bench?
It is connected to 48, my lord.
Regarding procedural lapses, my lord.
Yes,
In what?
in one, in 47.
47.
Because in
procedural-
that case, it was search-sheeted, my lord. That case is search-sheeted case. In a 302, this is the case when there's a case of search-sheeted and that is under the warrant. There are two cases. There's a distinction. Under a warrant, 47 is not required, my lord. Otherwise also, because it is under warrant, 47 is very specific. But I am on 48.
No, otherwise from the right now
Here,
the
this
present.
one is for on warrant.
No,
You're
no,
submitting
this-
this one is on warrant. or-
No, no, this is not warrant. This is not warrant, my
No,
lord.
no, this one.
This is a,
Regarding
this is
procedural lapses, my lord.
only procedural lapses and that
my lord.
is
And how?
in a warrant case. Warrant case, there is specific.
This is a warrant case. or-
Yes, yes, in a warrant, my lord. When they have come up for the cancellation, because bail was granted in this case, then come up for the cancellation, then the Supreme Court has held that there's a delay in furnishing the grounds of arrest regarding, and then said that then now this case is only distinguishing feature is that now it is burden has been given to the accused to show that the prejudice has been caused to him. That is the distinction has been made by this case, but this is purely on a warrant case. Otherwise, Bihan Kumar has also been followed. But this is a case in it because this case was suscited, my lord. It's totally different.
My lord, my prayer before your lordship, my lord, I have already pointed out regarding procedural lapses, my lord, because this matter is today listed for motion, my lord. Regarding the grounds of arrest, I will point out to your lordship, very serious offense, my lord. How this person by
No, I am not on the facts, my
that,
lord.
my lord,
First you
constituting
submit.
all these dispute, my lord.
My
because
lord,
I
that's
have
why I'm
also pointed out-
saying, my lord, I'm
No,
not
my
going
prayer
into the
before
facts
you-
of this case. Let him first say, in this case, in the Kamal doctor's case, he said only the intimation, only the case. What is my understanding of law is that only the intimation of the police case is not sufficient. You have to very assertively show it to the court that the need for arrest, that is the requirement of the Kamal doctor's case. You read it, Kamal doctor's case, the last line, the disclosing to the court about the need to arrest him another case. That is the requirement. Why he is wanted in another case. Then only you can arrest him in another case, not otherwise. If you can show that yes, he is wanted in another case, then you can immediately arrest him, but not otherwise. That is the mandate of the Supreme Court in all cases, my lord. First of all, you have to intimate the court, and not only intimation, need to arrest. That's more important. Need to arrest. Here, there is nothing in the forwarding report. Simply, they have indicated one case is pending, and the same day, why they have not forwarded me in the both the cases together, my lord? If that was registered and they are aware of the fact that she was in the forwarding report, they are aware of the fact that means that the Chanmari PS case is also pending, but they have not forwarded me in the Chanmari PS case. They are waiting for my release. Apparently, in the forwarding report, they have indicated that the one more case is pending. They could have prayed for, they could have brought me in the same day together, forwarded me in both the cases. Why they have not did it? So that they can arrest me moment I come out from the bail. That was the modus operandi of the police. They will keep one case, they will intimate also the court, but they will not share anything. What is the case all about? Then they have to arrest me again. That's not the mandate. That's why our High Court says the need to arrest, that is the requirement. And what has precluded them not to forward me in both the cases when they are aware of the fact? And one is Nunmati, one is Chanmari. On the way, they can brought me to the court on the same day. And both the cases are registered in the same day, on 10th itself. Why they have not arrested me in the Chanmari? Why they have waited? On 10th itself, because I have been forwarded on 10th. And both the cases are registered on 8th. Both the cases registered on 8th. I was arrested on 10th. One case. And they have indicated also regarding the pendency of the Chanmari case on that day. But they have not arrested. They have waited till I got the bail. The moment I got the bail, from the jail itself, they took me to the Chanmari police station. Then on that night, they have served the notice under 48 through the WhatsApp, which is not permissible. Then to somebody else who is not known to me, and he said, my signature is there. In the custody, my lord, there can be hundreds of signature of the accused in any paper. It does not indicate that I have authorized so and so. There has to be authority. That because it says that there has to be, I must authorize so and so. Where is that indication? Kindly show me that these particular 48 notice.
That's
Page
why I will
71.
to your lordship regarding procedural lapses, my lord. That, my lord, whether
And when there is
because
a,
of that,
yes,
any procedural lapse is there, my lord, whether the
that is the
petitioner
Bihan Kumar
says
says it's illegal detention.
now this decision is
No.
I will point out, I pointed to
The-
your lordship.
for that
And
procedural-
my learned senior has submitted that.
Which para you want to point?
My lord, our
But Lordship, kindly let him first submit whether this court covers this case. This particular case is covered. Simply one paragraph will not do. You have to read and understand everything. What is the circumstances of that particular offense, but that particular case related to this case? He has admitted that yes, there is a lapses. Now he says, yes, for the lapses, I am not entitled. But that particular case also shows that it created prejudice to the accused. Yes. Apparently, the language which has been served to me, suppose it was served to me my wife, it is in English. And they are saying that they have communicated in Assamese, the language which I have understood. So prejudice is apparent. That judgment says. So wife doesn't know anything, and if you have served it through in WhatsApp, what more prejudice is required, my lord, to show? Nobody know I was arrested, my lord. Directly from the jail, I have been taken to your custody. You have not arrested me on that day. The prejudice apparent in lead charge, my lord. Prejudice. I don't have to show. This court has said in that particular case, the delay in service, these are the prejudice. The now accused has to show the prejudice. But this is a case under the warrant, that's a different issue. He has to go through that's reflected in one particular paragraph also.
I have mentioned the paragraph.
And apart from that, it says now it is the prejudice has been caused. And this is particularly to 47. This is not to 48. This judgment is particularly to 47.
My lord, I would just like to point out, my lord, whatever is there, my lord, on the record, my lord. Here, my lord, yes, in the non-mati PS case, my lord, forwarding report, it is very clear that Sanmari PS case number is there. Whether he is wanted, that means that he is wanted in that case, my lord. And regarding Kamal Datta's case, my lord, in the Kamal Datta's case, my lord, while that Kamal Datta's case, Pasighat case, while he was granted bail, then there are two other cases, one Basar PS case and Itanagar PS case was pending, but those cases were not at all mentioned in the forwarding report of the Pasighat PS case. That is one aspect regarding first question, my lord. Regarding second, my lord, 47, 48, here, my lord, sufficiently complied with because, my lord, 47 notice, my lord, communicated to the petitioner, my lord, and 48 notice, my lord. Although, my lord, pointed out that regarding Supreme Court judgment, although, my lord, it is clear from the record, from WhatsApp message that was sent to the wife of the
When the WhatsApp message is
and
not,
Mobidul Islam, Mobidul Islam, who may be colleague of the present accused person,
maybe
that will come reflect only in the case diary, whether any authority, separate authority is there or not.
he said, my lord,
That will only reflect from
well,
the
the
case diary.
one time he'll
And
say the
regard of, my
colleague, one time he'll say the relative. Your notice says it's a relative, and I am the Mofidul Islam. This is the Mofidul Islam, and nowhere these notices says that I have authorized Mofidul Islam to serve the notice.
It is
They
not
should have
surprise-
incorporated in that notice itself that I have authorized. They simply said I have signed it. In the custody lordship, no, there are thousands of pages can be signed to an accused, my lord.
My lord, it is not surprising if, my lord, later on we have found that Mofidul Islam is, my lord, relative of the Dhan Kumar Deka. It is not impossible, my lord.
No,
Later on
that
also-
possibilities for that, can you curtail my liberty, my lord? That there's a possibility tomorrow, that tomorrow there may be something, so you may be tomorrow, your apprehension, you may be arrested, you may be in custody. His submission is that Mofidul Islam tomorrow maybe your colleague may be authorization.
Maybe not.
Maybe not also. Then what happens, my lord? One day custody as per the Bihan Kumar is illegal. That's why I'm saying, praying before your lordship to grant me the interim bail today and let them produce the case diary. Let them show that you have communicated in the language in Assamese in the case diary, because apparently it's not in the Assamese, it is in English. And you have said it, that I have communicated in Assamese, the language we understand. Because the Mohidul Islam, that means he doesn't understand English, as per your own statement. You have communicated through in Assamese, and you have served the notice in English. What else is required? And the Supreme Court says that you can't serve notices through WhatsApp. And you are serving it to the wife, to the WhatsApp. Why? You can go to my house, you can search my house, you can arrest it from in the previous case from the house itself. When both the cases are registered on the same day, you can serve the notice on that day itself to my wife. When you can serve the notice of the other notice to my wife in the previous case. Why you have not served this notice to my wife? They could have, but they want to avoid it, and then they have found somebody else, the Mofidul, just to bypass all these things, madam. Where is from the Mofidul comes into play, madam? So that's why I'm saying, in the forwarding you can write anything, but the notice, that's very important, 48. It has to be, I must authorize somebody. Then you produce that authority, that I have authorized. Where is that authority? They have to produce in the case diary that I have authorized. Simply taking the signature in that 48 notice will not do, because I have to authorize Mufidul Islam in the custody specifically, or somebody else. Then you can serve it to so and so. Simply taking my signature in some papers, is it a compliance of the 48, my lord? Nothing in that record, my lord. So that's why I'm praying, my lord. And the judgment he is showing, my lord, today, probably tomorrow, that will be coming up. That has been already, my lord, our High Court says no. Bihan Kumar will prevail regarding this man.
And
That's
just
very specific today in the division bench.
only two paragraphs, my lord, I would like to point out, my lord, from this judgment. That is, my lord, paragraph, I have 11.7.
Para 11.
Para 11 and my lord, Roman 7, my lord. And thereafter, the prosecution also strongly contests the High Court findings regarding non-compliance with Article 22(1) of the Constitution and Section 50 CRPC. The respondents were informed of the grounds of arrest orally at the time of arrest and served written grounds immediately thereafter. This process is in line with these court rulings in Ramkishore versus Directorate of Enforcement and Pravir Purukayasto versus NCT of Delhi. The arrest memos, checklists, and intimation documents were duly submitted before the magistrate and countersigned by persons acquainted with the accused. The requirement under Section 50 CRPC to satisfy the magistrate about arrest intimation was duly fulfilled. The High Court's instance that the actual grounds arrest must be filed in court finds no supporting law. And the chief may kindly come to paragraph 21(7) regarding procedural lapses, my lord. And see, just now I have got the judgment, my lord. Your lordship may kindly peruse the judgment and
No,
confirm.
I can distinguish this judgment also, my lord.
The present case, my lord,
Without
the
going
arrest
to-
memos and remand records reflect that the respondents were aware of the reasons for their arrest. They were
That is
legally
47,
requested
my lord.
from the house and applied for bail shortly after evidencing an immediate and informed understanding of the accusation. No material has been placed on record to establish that any prejudice was caused due to the alleged procedural lapse. In the absence of demonstrable prejudice, such as irregularity is at best a curable defect and cannot by itself warrant release on bail. So, my lord, these are, my lord, so from the present decisions of the Supreme Court, my lord, these are all curable defects. These are all
Constitutional right, my lord, can be curable, my lord.
And
Constitution, my lord, the
in
judgment.
this case, my lord, in this case, my lord, regarding Sanmari's PS case, there is, my lord, mention in the forwarding report and 47.
Yes, I have admitted there is a mention. My argument is that the mention will not do. You have to show that the need for arrest. That is my argument. Need for arrest. I am not on concerning of the mandate. If they are aware of the fact that there is one more case, why you have not produced him in the same date itself? In the both the cases, why you have waited so that I can be granted? When I will be granted bail, you will arrest me. That's not the mandate. That's why the need for arrest is more important. Need for arrest is why it is so important, my lord. That is why when you are aware of the fact that the one case is pending, you will keep it to yourself in your armory and suddenly you will take it out. It's not the mandate of the law.
Here in this case, difficulty is that on the same day, because 10/8, my lord, he was produced.
In the forwarding, yes.
On the same day, my lord, bail granted, my lord. That's why, my lord, on the next day, because of that case is pending, police right to arrest. There is, my lord, earlier Supreme Court Kulkarni, my lord, from the, my lord, there are some of these judgments that there is no bar, my lord.
I am not on that. Probably he is not understanding
Yes,
my proposition, my lord. My understanding is that the same day on 8th, both the cases has been registered. On 10th, you have registered in me in Nunmati PS case statement. In the forward, arrested me on 10th in the Nunmati. In the forwarding, you have reflected there is one more case in Chanmari is pending, but you have not arrested me in the Chanmari. You could have arrested me in Chanmari. You have waited for next 2 days. When I have granted bail in the next 2 days, again you have picked me up from the jail itself to the police station. They have shown me, they have arrested me in the police station. That means they could not serve the notices to my wife because I was not arrested from house. They have arrested me from there itself. They have arrested me from the police station. Then they have served the notices through WhatsApp. What prejudice?
If that judgment we have to rely on his judgment itself today, if that is the correct proposition as on today, suppose, then I have to show the prejudice, my lord. It's cost to me. Prejudice is letrage, my lord. It has been served on English language. It is served to somebody else. It is not served to me by the mode which has been prescribed, not the mode by WhatsApp that the Supreme Court says. You can't serve the notices through WhatsApp, not recognized mode of service. Then what else is required to show my prejudice, my lord? Prejudice is letrage enough, my lord, for interim bail, my lord. That's why I'm saying, because the one-day detention, if illegal, then tomorrow or day after, you produce the case that you can show me. Then you can cancel me on this ground that yes, it has been complied with, and this is the, and can it be, my lord, the judgment, I'm definitely, my lord, this is in par incurrem judgment which has been shown, because it does not tally the Vihan Kumar's paragraph also, surprisingly. They have quoted the Vihan Kumar, surprisingly, in that particular judgment, but it does not, my lord, they says in one paragraph 20.1.4 in the latest judgment, 20.1.4, what is, they've quoted the Vihan Kumar. Then I'll come to the Vihan Kumar, my lord. What is exactly, is there anything in Vihan Kumar in that line, my lord? They're quoted in 20.1.4 in Bihar Kumar by the state of Haryana. It was reiterated that Article 21 is satisfied if the accused is made aware of his arrest of grounds of in substance, even if not conveyed in writing. Similarly, in so-and-so versus so-and-so, it was observed that when arrest is made pursuant to a warrant, reading out, well, this is the case of warrant, reading out the warrant amounts to sufficient compliance. Both the cases, Pankaj Bansal decision clarified the written individualized grounds are not in inflexible requirement in all circumstances. Now, Lordship kindly see the Vihan Kumar in just above paragraph of paragraph 14, which they have quoted. Just above paragraph 14. Therefore, as far as the Article 21 is concerned, the compliance can be made by communicating sufficient knowledge of the basic facts constituting the grounds of arrest. The grounds of arrest be effectively and fully communicated to the arrestee in a manner which is fully understood in the same. Therefore, it follows that the grounds of arrest must be informed in a language in which the arrestee understands. This is how, in the case of Pankaj Bansal, this court held that the mode of conveying grounds of arrest must be necessarily and meaningful so that it to serve the intended purpose. However, Article 21, there is no requirement of the communication of the grounds of arrest in writing. Article 21(1) also incorporates the right of every person arrested to consult an advocate of his choice and the right to be defended by an advocate. If the grounds of arrest are not communicated to the arrestee as soon as may be, he will not be able to effectively exercise the right of consult the advocate. The requirement of the incorporated in Article 21(1) also ensures the grounds of arresting the person without a warrant exist. Once the person is arrested, his right and liberty Article 21 is curtailed. When such an important fundamental right is curtailed, it is necessary that the person concerned must be understand on what grounds he has been arrested. So this is only been quoted, but nowhere, my lord, this is Article point 20.14. And ultimately, Vihan Kumar says the written is mandatory, my lord, in the Vihan Kumar, the earlier judgment. The Purakasta, all other judgment has said that thereafter also, the written communication is must. And they have followed that also. It's not that they have not followed it, written. If that be so, then there's no necessary even. Then why you have followed that? You have followed that, 48. But now, to bypass the 48, you have served it through WhatsApp, which is not permissible. My contention is that if their contention is accepted for today, my lord, that I have to show. But the Vihan Kumar otherwise says that it is for the prosecution to establish. There's one paragraph. And Lordship kindly see this judgment which he is relying on. This is come out in August 14. And I've been arrested in this case on 12. Then also, my lord, then it's not, at that point, it was not even not existed, the judgment, which he is relying on. Then in the Bihan Kumar, also, the one paragraph, Lordship has seen it, that it is the duty of the arresting authority to establish that they have followed that. The conclusion in, then when a violation of Article 21 is established, it is duty of the court to forfeit the order the release of the accused. That will be a ground to grant the bail, even if statutory restriction on the grant of bail exists. The statutory restrictions do not affect the power of the court to grant bail when they violate the Article 21, 20 of the Constitution is established. So when there is a violation of the Article 21, there is no need to show the prejudice. There are thousands of judgments, my lord. Thousands of judgment. When there is a violation of the Article 21, I don't have to plead prejudice, my lord. And the C says, when the arrested accused allays non-compliance with the requirement of the Article 21, the burden always will be on the investigating officer to prove compliance with the requirement of Article 22(1). It is the burden on the state or the investigating authority. Now, in the judgment, burden has been shifted to me, my lord, without discussing this provision. So this is the, my lord, the par imperium judgment, this new judgment. And this judgment also does not exceed the existed when I was arrested. That at that time, Bihan Kumar was there, Purkasta was there. I was forwarded on 12th of August, my lord. And the judgment has come up on 14th. Then also, so that's why I'm saying, my lord, this is an absolute violation of the 48, my lord, and the judgment pertaining to the 47, because in that particular case, what happened, my lord? In the arrest memo, grounds was there, this particular case, my lord. That is why it was segregated, that he was already aware in the arrest memo itself. There's no notices, but in the arrest memo, the grounds of, yes, so substantial compliance was there. That's why Supreme Court has segregated that. That is why.
My lord, I would like to conclude, my lord, by submitting one thing only. But here, my lord, as the decision pointed out by my learned senior regarding Kamal Datta was followed, my lord, as because that Sunmay decision case was specifically, that means he is wanted. And regarding other 47, 48, my lord, it is not that, my lord, prosecution has not complied with.
Yes.
All those notices were served. And in that notice, my lord, regarding Mobidul Islam, whereas his colleague or relative, that will come only in the CD, but his signature is there. And regarding other, my lord, gravity of the offenses, how he has collected money from different candidates, experience, my lord. And
But that
regarding
means
some of the
if he goes into
other
that, my
aspect,
lord,
if something is required to be clear,
in
then
that case,
CD,
if he
I
goes
will
into
clear
court,
it.
my lord,
So my prayer
factual
before
aspect, my lord,
at
there
this
are
stage only case diary.
all these similar cases. The Chanmari Nunmati is just a cyclostal copy of the each case, my lord. Both are same. And he said the indication of the grounds of in the forwarding report regarding the pendency of the case itself shows there is a need for his arrest. That is his argument. That is simple, that they have shown that the indication that they have mentioned about the Sanmari case, it itself indicates that he is wanted. If he is wanted, why you have not arrested me? If I am wanted in that case, what has stopped you from arresting me? I am already in your custody. You could have arrested me in that case also if you wanted me. Now he is in the, says that yes, he is wanted. If I am wanted, why you have not stated in the forwarding? The requirement of the Kamal Kumar is that they need to arrest. You have not indicated the need to arrest. And if there is a need to arrest, why you have not arrested me on that day itself? And you have waited. The moment I got the bail, you have arrested me again. This is absolutely violation of the Kamal Kumar's case, my lord, Kamal Datta's case, my lord. That's all, my lord. So I pray, my lord, the interim bail may be granted at this stage. Let the case diary come, and case diary will definitely show that this man is absolutely no way connected with me. And I have not authorized. The requirement is that there is one more requirement is, my lord, Lordship kindly see why this is so important. Lordship kindly see 48. There is not only the Now the police officer shall inform the arrested person of his right under the subsection 1 as soon as we brought to this police station. The entry of the facts to whom which in inform of the arrest such person shall be made in the book in the kept in the police station in such a form as the state government may by rules provided.
Yeah. What says
এইটো
48?
কোৰ্টটো কমপ্লাই কৰা বুলি কৈছে নিউজ পেপাৰ অৰ্ডাৰটো আমি কাটি দিছোঁ এইটো লাগিব ন নাই নাই এইটো কথা আৰু এটা আছে ন এইটো আছে ন এইটো my lord 41(8), that's why it that intimation also to the designated officer in the district, that is also another requirement of the 48. There has to be a designated officer, and designated officer also been 37 is there who is the designated officer. They also in the 47 they have to also intimate to the designated officer. That has to be also forwarded to the designated officer because they can always by means of that mode that showing it that it has been served to so and so. That's why they need it. They have to intimate the designated officer also regarding compliance of the 41. And the dated, and moreover, the 48 is undated, my lord. Lordship, kindly see, it's undated document. No dates. Lordship, he is saying that there is a signature of the accused, but the 48 does not. On which date you have served to me? Where is the date? No date of this below the signature of the accused, below the signature of the IO. How can you construe that this is a notice served to the Mohidul Islam, my lord? Even no undated document, you will file an undated document to the court for the compliance. It shows that the prejudice has been caused to me, my lord. Apparently, my lord. No date, my lord. One is through WhatsApp, other is without date, without the person. They say he is a relative. Public prosecutor said he is a colleague, he may be colleague. Everything on may or may not. That's why I'm saying that the one-day detention is curtailment of my legal rights, my lord. That's why I'm praying for the interim bail at this stage. Let him bring all the, then it will come up, my lord, the other factors also regarding my involvement. Because there are 2-3 cases where I have been granted the privilege of anticipatory bail in the same case, madam. When there is no material, that is also there. Elaborate order is there.
Okay.
In a similar case, in a case of Mahbubul Haq, my lordship has granted privilege of interim bail in the same condition, because non-following of the mandatory provisions.
My humble prayer before Lordship, considering the matter in entirety, my lord, to decide the entire issue and to, my lord, solve the entire dispute also, my lord. Your Lordship may kindly peruse the case diary. After perusing the case diary, if there is any lapses, your Lordship may decide, considering the gravity of the offense, my lord. At this stage, only case diary may be revealed, my lord. Case diary may be called for, my lord. And
when there is a violation, my lord,
after considering the case diary, my lord,
when the Bihan Kumar says, my lord,
your Lordship may
the gravity of the offense is not the mandate in the 47-48, my lord. Gravity of the offense, he is arguing, when there is a violation of the 47-48, the gravity of the offense cannot be. You are not trying me, my lord. You are not convicting me to see the gravity of the offense. I am presumed to be innocent as far as the jurisprudence is concerned, my lord, until I am proven guilty. Where is the gravity of the offense comes into force, my lord? I am surprised, my lord.
Okay.
When my arrest itself is illegal, my one-day detention is illegal, my lord. And on the face of the record, I am not pleading that it may not be served, may be served. On that case, yes, Lordship can call for the case. When it has been served, apparently, on the face of the record, through WhatsApp, through an unknown person, an undated copy, and that too in a language which is not understanding. What remains? What is the Requirement, more requirement, prima facie, my lord.
Mr. Baral, but your, okay. Yes, what is it? Item number.
Let me clear. My lord, your losses may just see the FIR, my lord, which is in my affidavit at page 22.
22.
20,
Yes, the office note on.
my lord, page 21. Page 21.
No, 21, that's full.
See my
My lord,
Yes,
page,
Lahore has gone through the my lord. He has
Lahore.
left for another court, my lord.
my lord, this is,
After
No, no,
some,
where is,
after some time,
no, time, I'm just, this is the last one. I will not going.
my lord.
my lord,
The office note is there, one, colored number.
no, we have filed, my lord, we have entered appearance, my lord.
Huh?
In place of earlier one, my lord, he received NOC, we have entered, my lord.
You have entered into it.
Yes.
Acha.
My lord, your losses may just see page
So you
21.
are appealing for informant.
Inform.
That you will be in a position to see this, or we have to wait for law, because we don't have time. Okay, sure.
My lord.
You can.
Yes.
My lord,
Is it okay for you?
my lord, I will have to go to it, my lord. He has already in another court, my lord.
Where is law?
My lord, yes.
Law, where is law court?
Court number 13, my lord.
Huh?
Court number 13, my lord. 13, my lord.
Court number 13.
But if your losses see the my lord, FIR,
No, actually, I will see the FIR, but now this Mr. Lawford was, that's what I'm just waiting for him.
My lord.
He is available.
my lord.
Otherwise,
Because-
if you can go by the record, I can hear you.
Yes.
No, no, Chimney.
Yes.
Okay.
Just, my lord, I want to place, my lord. There is no case at all, my lord.
FIR is at page number.
At page 21, my lord, my affidavit.
Your affidavit.
Yes. Because originally it was not there.
Does it?
This is a case for passing, virtually, my lord.
Huh?
This is a case for passing, my lord.
Subsequently, you file the FIR, copy of.
Yes.
Okay.
My lord. Initially, it was,
It was not there.
small for my
So
lord.
that is why, my lord, page 21, I am.
Yes, what is it?
My lord. Your losses got it, my lord? Page 21. I, Jahnavi Agrawal, daughter of Gopal Agrawal, resident of Hatigaon, so and so, wish to lodge the complaint against Harsh Garodia, son of Vinod Garodia, resident of Konok Apartment, Jurpukhuri District, Kamrup, Assam, so and so. We met in July 23 via social media and later developed a relationship. He claimed he was getting divorced and promised to marry me. He established a physical relationship with me on multiple occasions, taking advantage of my trust and emotions under false promise of marriage and commitment. And on 24th November, we got married. My lord, he says that on 24th November, we got married at Dukrata Mandi Ujjan and stayed at night at Kiran City Hotel, Grand Hotel, Guwahati. We lived together as husband and wife since then. Despite continuous requests, he refused to introduce me to his family member, made false promises, and later disappeared in me. My lord, my offense is that I did not introduce to my family members. Otherwise, where is they married? As per her also we are married. Then where is section 69, my lord? Then, your losses may see. When I asked him to involve our families, after taking it down, his parents, number so and so, so and so, so and so, threatened me and my family with legal action and forcibly took him away. Well, where is the offense? This case is registered under section 69. They have married. The informant said that we have married and we live together since 23 to 25. Since November 23 to May 25. They live together.
2 years.
2 years, about 1.5 years. Then where is the offense? Section 69 you also see. On the face of it, my lord, there is no offense. Huh? My lord, may see just section, my lord.
Sexual intercourse by employing deceitful means. Whoever deceitful means by making promise to marry a woman without intention of fulfilling the same. Without an intention of fulfilling the same. Here the informant herself says that they have married and they live together for 1.5 years. Then not introducing to it really, my lord, is it an offense?
Later he sees the family member that
My lord, there is no offense, my lord, virtually. There is no case at all. On the face of it, my lord, it's a case for passing, my lord. Initially, I was not there, otherwise, my lord. It's not a case at
My
all.
lord, here is a Lordship may kindly page the statement of the complainant victim, my lord. Here, what happened, my lord, she was also divorcee, and the present petitioner is to divorcee, my lord.
no,
And
My lord, she married
And that-
4 times, my
that
lord.
case
Later
is-
on, we can.
divorce case is pending, my lord, for a present petitioner, my lord. And when the victim's father and mother wants to meet the father and mother of the my lord, present petitioner, my lord, and then from the death, my lord, he is my lord, not cooperating, my lord, not here. He's
That is not an offense under section 69.
and what I am understanding, my lord, from the statement, my lord. And the last person I will notice also there, my lord. And the statement reveals my lord, complainant, my lord.
The girl is, my lord, 4 times married. One is
That is-
divorced. Others, actually, we don't know, my lord.
That is different
Later on, my lord, we came to know.
from the statement of the complainant, my lord, it reveals, my lord.
Because that has been stated in my.
And mother's statement, father's statement is also there, my lord.
My lord. But this is not a case, my lord, for custodial interrogation. Because since there is no case at all. '69 is not affected at all.
When the father and mother of the my lord, victim asks about the marriage, my lord, to the present petitioner, my lord, then from that day, my lord, he is not here, my lord.
That is unacceptable matter. But they married, live together for 1.5 years. 1.5
Marriage,
years.
that is, my lord, in 1 year, my lord, but due to the divorce petition is pending, my lord, against the present petitioner, my lord. So he is unable to, my lord, as per statement, my lord.
That was known to her.
He never wants to introduce, my lord, his father and mother to the present petitioner's mother and victim's father and mother. That is it.
That is not an offense.
May it please your lordship. Lordship, the issue at hand here is whether the current case constitutes an offense under section 69 of BNS. Now, from my understanding, for an act to be an offense under section 69, there must be 2 ingredients. One, there must be a false promise to marry, which without the intent to fulfill, and 2, in pursuant of such a promise, there has to be a physical relationship. Now, to prove my point, Lordship, regarding the false promise, the petitioner in this instant case is a married man. He was married, and in fact, his divorce proceeding is going on in the state of Dibrugarh. This is the copy of the case report, Lordship. It's fixed on 22/8/25 for a commissioner report, as you can see, Lordship. Furthermore, Lordship, in pursuant to this marriage, the petitioner and the complainant, the informant, they underwent a relationship and subsequently they got married. Now, Your Honor, it is the law of the land that when a man is already married and his case is already pending, he goes on to for another marriage, which is void in nature under the Hindu Marriage Act. Despite that, Your Lordship, and it is pertinent to note that the new marriage which they have spoken about is not registered under the Special Marriages Act because they are aware of the fact that it is void in nature. In fact, Your Lordship can see these are the photographs of the marriage. Yes, Lordship, it is a fact that they have gotten married, but this marriage itself is void from the inception itself. And second point, Your Lordship, with regard to establishing a physical relationship in pursuant to such a false promise. Lordship, from the FIR. Lordship, from the FIR, it is clear that after this bogus marriage ceremony, they have lived in a domestic relationship. They have gone for their honeymoon, and subsequently they have undergone physical relationship. And after all of this, the instant petitioner has abandoned the instant informant, and he has started to harass her and threaten her to not interfere in her life. Your Lordship, from my limited understanding, this constitutes an offense under 69 in view of the fact that one, there was never an intent.
Is there any material to show that she was not aware about the fact that
She was aware,
No,
but
she was not
but-
aware of the
but-
fact that the
but-
divorce case is still pending
Lordship,
against
she
the,
was aware, but
the petitioner?
Lordship,
Was there any awareness from her side?
Lordship,
Because this is not a case that a young girl and young boy got married.
Lordship.
It's not a case of that nature.
Lordship,
Case is that she was also a divorcee or whatever,
Lordship,
and he is also in same footing.
Lordship.
So now you are saying that he's this he suppressed the fact that
No, Lordship, it is an admitted.
that in that case she was aware of.
She is an admitted fact that the petitioner had told the informant that I'm getting divorced. Now, in the process of this, he tells her that my divorce has been completed, and as such, I'm marrying you. But that was contrary to records because his divorce case is still pending for the district. The divorce case was still pending, but she was under the impression, her consent was obtained on that impression that the divorce matter had been settled, and as such, she got married to him.
My lord, the affair still shows, my lord, that he was getting divorced. That the divorce is pending.
Hmm?
He was getting divorced.
Where?
That was in written. Second prayer. Claim that he was getting divorced and promised getting.
Yes, Lordship, this
That was pending. That is pending. That was informed, my lord, everything, as per the affair itself. And thereafter, in spite of that, my lord, she married and lived together for 1.5 years. My lord, where is the ingredients of section 69, my lord? I know from that law. 69 cannot be affected.
Mr. Sharma, in her statement also, is there any such thing in regards to that by suppressing?
Not suppressing it.
It's not here at all.
Not suppressing, not suppressing. He also informed that it was the divorce proceeding is going at hearing.
Yes, any other?
Lordship, as they have pointed out, from bare reading of that point, he claimed he was getting divorced and promised to marry me. So, Lordship, this can be interpreted in the way that perhaps they met in the beginning and yes, we got to know each other. I'm getting divorced soon. Let us marry. It can be interpreted that way on plain reading of that.
So now see, again, I'm saying that you are not a young girl of say 1920.
Lordship.
You are a mature woman of more than 30 years. So you know the consequence. If divorce is still pending, better not to enter into that relationship, because otherwise it is an admitted fact that you got married in a month and you stayed together more than 1.5 years as a husband and wife, in spite of the fact that the case is still pending before this so and so. So that is there in fact.
That's my contention itself is that I was not aware of the fact that the case is still going on. I was under the impression that this matter was settled. That is why I.
And apart from the Mr. Sharma, do you want to submit that the custodial interrogation is required here in this case?
Regarding my custodial interrogation, my lord.
Otherwise, you are that in that case, we subsequently got a report. Huh?
My lord, initially
That
the
is
report
the
was
case.
called for,
Okay.
my lord.
So
And
you
then-
are not on interim in that.
No, interim was not there, my lord. And he is a chartered accountant, my lord, by profession. They put it contract.
Oh, Administrator S. Sahebala. Well, sorry, GN Sahebala. The learned senior advocate, assisted by
M. Sahewala.
Mr. M. Sahebala. And and also heard Mr. Sharma Lilani. Respond. And Mr. You are Mr.
And R. Sharma.
And Arsha. And Arshama appearing for the informed. Next question. This is an application. CD receipt, submitted by Mr. Sarwala that it is subsequently received the obtained the certificate copy of this FIR, which has been annexed along with their additional element. Next for Mr. Sun, done it. Senior counsel for the petitioner submitted that cases there is no ingredients at all in the FIR itself to attract section 69 BNS. Rather, it is a case where both the petitioner and the victim were in a romantic relationship, and out of which they got married in the year 2023. And since 2025, they were living as a husband and wife after their marriage at Ugradaramandi. The only allegation against the present petitioner is that he did not introduce her to her family members earlier and avoided risk. On that matter of allegation, it cannot be a case under section 69 BNS, which has been registered against the present petitioner. Rather, maybe a case for quashing of the entire. Next, Mr. Sharma, the learned recently submitted from the matters available case diary and a special statement accorded a statement of the victim itself. It is seen that that with the false promise of marriage, the false promise of marriage, they were in physical relationship, and subsequently he avoided her when she pressurized to introduce herself with his family members. But as submitted that from the matrix available in the case diary, this may not be a case to grant the privilege of rearrest. Mr. Sharma, the learned counsel appearing for the informant, submitted that the two ingredients which is required to fulfill section 69 BNS is available in the present case, and the petitioner had the intention to receive the complainant, informant from the very inception of their relationship, and from the inception of the relationship, and with the false promise of marriage, he had physical relationship with the present with the victim. Further, Mr. Sharma submitted that the case of divorce is still pending against the present petitioner, but that's suppressing the fact and giving an impression to the victim that the divorce case is already over. They entered into a marital relationship. Mr. Sharma clearly raised objection and submitted that this is not at all a fit case to grant the privilege of rearrest bail to the present petitioner. Next paragraph. During the submission made by non counsel sites, that also fits the case diary and the considering the materials available in the case diary, it is seen that there is no indication by the petitioner, by the victim, that she was not aware about the tendency of the divorce case of the present petitioner. And that apart, it is also seen that from the in the FIR itself, it is stated that petitioner gave an impression that he is getting divorced soon, and for which only they entered into a marriage in Ugradaramati. Considering all these aspects of the case, and it is available is that find that custodial intervention may not be necessary in this case, according and it is to extend the privilege of pre-arrest bail to the present with the some conditions. There will be some conditions, you abide by all the conditions, otherwise you are granted with the interim, oh sorry, pre-arrest bail.
Interim.
No, pre-arrest bail.
Pre-arrest.
Actually, you are granted with the pre-arrest bill, there will be some terms and conditions
Yes.
abide by all the.
Well,
My lord, regarding item number 36 and 37, my lord, supplementary hearing, my lord.